The Lordship, there's a contempt matter and a writ of appeal. Lordship may kindly hear it anytime in case urgency in both the matters. The Lordship, in one of the matters, I'm the CEO and I have been forcefully vacated from my office. Much of it.
Lordship, may I mention item number 96, 96.1? Lordship, 96, 96.1 and 96.2. The connected matters 96.1 and 96.2. So these are contempt matters and a writ appeal. Lordship, wherein the directions of Lordships and their undertaking. Yes, Lordships. There are several undertakings which are given by the opposite side. That is, sir, Advocate Miss Vandana is there, and I've already informed her that I will be mentioning the matter in the morning, and our Lordship's convenience, Lordship may fix it anytime in lunch. I've already informed her, Lordship's convenience, Lordship may fix it. One, Lordships.
Submission matter. File and transfer application. Court number 4 to some other court. The contempt petition is not considered by the court number 4. Kindly have it tomorrow. Hearing date is 12th February. Before that, I am transfer because the contempt petition. This honorable court may not. This honorable court may not consider transfer application. This honorable court, my lord, please to pass order in 1883 March 2000. Before this court, transferring from court number 4 to this court. Please, my lord, this honorable court, because the court is not allowing me to argue the matter on main merits. Court is not allowing me to argue the matter directly withdrawing. This, can you see this honorable court pass orders, my lord? This honorable, please. This honorable court was pleased to order, pass orders, my lord. Kindly.
My lords, with your lordships, kindly. My lords, this is a fresh writ appeal, my lords. The learned single judge has directed the DRT to refund court fees, even though there is no such provision in the rules. My lords, this has serious financial ramifications for DRTs across the country. There's a period of 4 weeks to do the same, my lords. The writ appeal is ready for posting. Compliance is also done. May I request for it tomorrow or day after, my lords? My lords, may I request for an earlier date, my lords? 4 weeks is the time to refund the amount. The appellant is the registrar of the DRT. My lords, 4 weeks is expiry, has already expired, my lords. This is the second memo I'm moving. Very well.
But this is with respect to the public litigation. This time of course, my 18th miller. Kindly considered my pleadings, but this court is not allowed directly withdrawing. Pleadings in 18.3, but it is not considered. There is a case on merits, my lord. He is suffering, the complaint, husband is suffering from cancer, my lord. Kindly have it tomorrow, my lord. Tomorrow, my lord. Tomorrow. 12th is the hearing date. I may be considered. Transfer it. Maybe, sir. Please, because to meet the ends of the justice, my lord, he directly is withdrawing all. But the court is not concerned with this order also. Single judge order also, directly withdrawing. I will lose my client. Husband is suffering with cancer, my lord. On 27th, it was came, my lord, so far. It is some other any court. Otherwise, he will lose his life, my lord. It is life and this. Yes, 27th has come, but directly is going to withdraw my contempt petition without considering the single judge order and as well as this honorable court, my lord. Kindly, my lord, my humble submission.
But this is petition with respect to public interest litigation, not for the purpose of consideration of classification under SCH Act, for the purpose of reservation. Now, let's say again, if that a Supreme Court judgment, the respondent are trying to fulfill the backlog judgment. That's why there is an urgency. No, respondents are trying to fulfill the backlog jobs, not say again, if the Supreme Court judgment, with respect to the consideration of subclassification under scheduled caste matters. Please.
Serial number 31, my lords. 31. 31 and 31.1, my lords. We are requesting to adjourn the matter. We have informed other side, my lords. Well, some personal inconvenience to do. Grateful.
Serial number 25, your lordship, I appear for the petitioner. It's a fresh matter. Seniors traveling, my lords, it requires some substantive hearing. The matter may be taken up next week, your lordship. That's the seniors traveling, my lords. Serial number 25, sir.
Serial number 23 minutes.
Serial number 20, my lords. This is a contempt petition filed against the accused for not obliging with the order passed in a GNWC case, my lords. That order has now been apparently stayed by WP. I kindly seek 1 week's time for clarification, my lords. Because I have not received notice, neither have I received copy of the WP, and I tried checking if there's a stay, my lords. The other side just informed me yesterday in person that the... My lords? Yes, regarding admission of the son, my lord. I'm for the person who's filed the contempt petition. I'm for the petitioner. The accused is supposed to come and make the submission, but they only informed me in person yesterday that there is a stay on this order. Therefore, I seek 1 week's clarification. 1 week's time for clarification.
Serial number 20.
Seven.
Serial number 20, I am for that. The order is stereo. It does not, sir. It may be dismissed. I have the order, copy of the order also. Yes, yes.
It is
Yes, it
stayed.
is stayed.
Correct.
By the single judge. Honorable sir. I'm for it.
Serving liberty for the complainant to approach,
Your lordship.
if required, at appropriate time, on the basis of first cause of action.
Your lordship. Serial number 44, lordship.
इससे पहले learned respondent does not dispute the position that
Appearance report.
the petitioner does not dispute the position about this order having been stayed.
Serial number 76, my lords. 76.
76.
Yes, my lord. For the appellants, my lords.
What do you want?
A week's time may be granted, my lords.
Week time will not be there. Then it will go to March, 13th March.
Much of.
Your lordships kindly, Serial number 35, my lord, serial number 35. 46 identical matters your lordship has already ordered to be posted on 18/2/2025.
What,
46 identical matters. This matter is listed by mistake today, my lord. It may be
Why is
taken
it
up on
getting-
18/2, my lord.
Sir, please wait, sir. Mentioning through VC, please wait, sir.
why it is getting adjourned from time to time regarding national education?
My lord, sometime 2 weeks' time may be granted, my lord. I just received the instructions
Let us
yesterday.
put an end to that. 10th March,
The Lordship,
as requested. Before which time the reply affidavit, if any, shall be filed by the state.
Lordship, serial number 44. Senior has having some personal income.
44.
Notice has been served.
42.
44.
44,
44.
19th March,
Much ago.
as requested.
My lord, serial number 62, my lord.
62.
2 weeks' time, my lord. Serial number 62.
62.
Yes, ma'am.
That was a request made by the council, learned council petition, stand over to 19th March.
Serial number 64, my lords. 64.
Yes, Mr.
My lord, serial number 82.
82.
I have filed an application for amendment of class title A3, my lord. There is a typing mistake. So that is not heard of. Unless say it is allowed, I cannot take steps against A3 for serving the
Where is that application? Number,
IA
number,
on
it is listed today.
82. IA number 1/24.
So you want to change the name?
I want it to be heard in a preliminary hearing, my lord, because several times it has mattered
IA is for what?
for amendment of caste title. The name of A3 is Ranjiv Kumar. It is typed as a Rajiv Kumar. So that because of that I am not in a position to.
IA number?
IA number 1/24.
1 of 24, heard learned counsel for the respective parties, this IA is filed seeking amendment in the course title, more particularly in the name of respondent 3. Respondent number 3.
A3 is against A3 it is.
Appellant,
Number 3.
respondent number 3,
Name of it.
whose name is wrongly typed as
Rajiv Kumar instead of Ranjiv Kumar.
Rajiv Kumar, whereas the correct name is Ranjiv Kumar.
Ranjiv Kumar.
Full stop. The course title, the amendment is permitted in the course title as prayed for. It shall be carried out within 1 week. This application is allowed.
Obliged.
After the amendment is carried out, the official immediately list.
I may be permitted to serve he is serving in Lucknow, Canara Bank Lucknow. I may be permitted to serve in Lucknow.
So then we issue notice after the amendment is carried out. The registry shall issue notice to the respondents returnable on 17th March.
Serial number 64, my lords. I appear for accused, my lords. I have recently filed wakalat, my lords. I need time to file objection, my lords.
64.
64. my lords.
When do you want? 19th March,
Yes, my lord.
in order to enable learned counsel the respondents now, so and so to file his wakalat now. Yes.
Serial number 77.
70.
The order, the writ appeal method challenging the order passed by the learned judge. Writ petition number 1344 was passed by
77, not to be placed before the bench, where one of us interpret honorable Mr. Justice. Am I Arun? Bracket on is a member. 74. Hmm? 74 same order, 75 same order. All format, all letters, not to be placed before 74, 75, 76, 77. Check, just check it.
Serial number 35, my lord. There are about 46 of gratuity matters, identical matters. It's all ordered to be listed on 18th February.
Yes, my lord. I appear for caveator, my lord.
As the connected matters are listed on, going to be listed on 18th February, please Writ appeal shall also be listed along with on 18th February.
Published.
Much obliged.
Any mention through VC, sir? Cell number 1. Sir Rahul is ready.
Appear for the appellants in this matter. my lords.
3 to 17. 7.
Appellant, my lords, is the president of Gram Panchayati named Begli Hilli Vasali Gram Panchayati. She has been elected as a president, my lords, during the year 2020-23 in August. Now, my lords, currently she is serving as a president. What happened in this matter, my lords? There are total strength.
Is any notice is not given?
No, my lords, notice is not. Notice is not yet ordered, my lords.
Notice to the members are not given.
Notice to members have been given, my lords. So 15.
Wrong with the order.
Now, my lords, what I urge is, my lords, a fair opportunity had to be given to me when a no confidence motion letter was issued to the Assistant Commissioner. Without giving a fair opportunity, my lords, section.
There is no such provision. It is to be tried in the board before the body.
My lords, what has happened in this case, my lords? Section
For giving notice for.
48(4), my lords, will tell that, my lords, a removal of an Adhyaksha or an Upadhyaksha, a fair opportunity to begin.
You are
But
arguing entirely
does not,
unknown proposition, which is not acceptable in law.
But now, my lords, though it does not tell for a no confidence motion, my lords, but an opportunity to, now, my lords,
What opportunity? It will be given in course of the motion.
my lords, there is no specific allegation with regards to misappropriation, either misappropriation of funds or assets of the Gram
One a single
Panchayat.
judge rightly said that this is not a stigmatic action, giving notice. You have to be tried. This is a democratic process. There is no stigma until you are adjudged. Even then, we doubt whether it is stigma.
Now, my lords, immediately after dismissal of this, my lord.
That concept of stigma can't be imported here. It's entirely different nature of process.
Now, what happens, my lords, in view of the meeting conveyed, today the meeting has been scheduled. The no confidence motion will be moved, a resolution will be passed, and I'll be removed from the post of the Adhyaksha.
We do not know, you can defend, it's a democratic.
That is what happens, my lords. So at least section 48(4) will tell.
You are able to show any statutory infraction in the procedure, non-giving of notice, no requisite.
That's what I wanted to point out to my lords is, my lords. 48, section 48(4) of the act will tell 48 is, my lords, resignation or removal of an Adhyaksha or Upadhyaksha. 4 in, my lords, if I may permitted to read, every Adhyaksha and Upadhyaksha of Gram Panchayati shall, after an opportunity is afforded for hearing him, and if necessary, after obtaining a report from the Taluk Panchayati, and considering the same, be removable from his office as Adhyaksha or Upadhyaksha. Though, my lords, this does not tell for a no confidence motion, this is for removal of an Adhyaksha.
Which provision?
Section 48, subclause 4, my lords. 48 reads is, my lords, resignation or removal of Adhyaksha or Upadhyaksha. Provision 4, my lords. A no confidence motion is, my lords, nothing but a removal of an Adhyaksha.
This is about removal.
My lord,
Yes,
this
my lord,
is
sir.
a removal by the government, my lord. 48 is removal by the
The
government.
penal action. This is a democratic
It
process.
is not a case of removal by the government. Yeah, the
No.
members have given a notice.
That is the whole sole ground of this, my writ appeal, my lords. Thereafter, my lords, what has happened? After dismissal of the writ petition, my lords, the Assistant Commissioner has issued one more notice calling for a meeting. Any meeting to be convened, my lords, there has to be a clear 10 days period. The present notice issued, my lords, does not give a 10 days time, my lords.
Lord Learned Advocate Mr. So for the appellant original petitioner. For my learned additional government with Harish for the respondent number
1 and 2.
1 and 2. Respondent number 1 and 2.
3 to 17, Venkat Ramana Reddy.
Learned senior advocate.
V. Srinivas for Venkat Ramana Reddy.
So and so.
Venkat
Assisted
Reddy.
by learned for respondent number
3 to 17, my lord.
3 to 17. The challenge in this appeal is addressed to judgment and order of Learned Single Judge dated 22nd January 2025, whereby the writ petition came to be dismissed and the prayers made in the petition came to be negative. Full stop. The petitioner was agreed. A motion of no confidence moved by the 15 members of the Gram Panchayat. Full stop. Pursuant to the motion moved with requisite majority of the members, comma, the competent authority does the assistant commissioner convened a special meeting. Full stop. The petitioner called in question, said exercise, full stop. Before learn a single judge, as well as this court in appeal, the solitary argument which was advanced by a learned advocate for the appellant was that the, before moving no confidence motion, comma, the opportunity of hearing should have been given to the petitioner. The petitioner, you are what? You are Upadhyaks or?
No, my lords, Adhyaksha, my lords.
The petitioner who held the, he held the post of Adhyaksha of the Gram Panchayat. Full stop. The paragraph, the submission is entirely misconceived. Full stop. As learned single judge has rightly observed in paragraph 6, that as per rule 3/7 of the Karnataka Gram Swaraj and Panchayat Raj, interrogate motion of no confidence against Adhyaksha and Upadhyaksha of Gram Panchayat. Bracket over rules 1994, comma. The Panchayat is required, Panchayat would consider the motion of no confidence without hearing any debate. Full stop. It's rightly observed that merely because a motion is made, it cannot be treated to be an automatic stigma. Full stop. Motion of no confidence is not a stigma attached in the sense conceived in the service jurisprudence. Learn a single judge is further correct to observe that the learn a single judge observed correctly further that the reasons given in the no confidence motion could be merely the cause for which the members intend to move a motion of no confidence, and it will not require any inquiry or hearing to be given to the petitioner. Paragraph. Learned advocate for the appellant sought to rely on section 48 of the Karnataka Gram Panchayat Raj Act. No allegations are required. 8 section deals with the resignation or removal of Adhyaksha and Upadhyaksha to provide in its subsection 4 that before taking the action, before taking action of removal, an authorization should be awarded to the Adhyaksha or Upadhyaksha as the case may be. Full stop. The said provision plainly foreign to the controversy in as much as it deals with the situation of resignation or removal of Adhyaksha. Full stop. Conceptually, paragraph. Motion of no confidence is entirely different than removal, where no hearing would be required. Full stop. Motion of no confidence is a democratic process whereby in a democratically elected body, Adhyaksha or Upadhyaksha could be removed once he loses, could be unseated once he or she loses confidence of the members of the requisite majority statute, which may be statutorily prescribed in the provision permitting the moving of the no confidence. Full stop. The judgment and order of learn a single judge, paragraph, is eminently just, proper and legal. No interference is called for. The appeal is merited. It is dismissed.
Please.
All the interlocutory applications stand dismissed, stand disposed of in your dismissal.
Seal number 2, contempt matters. Mahesh.
My lord, this matter pertains to an illegal construction on a KIDV land. If my lords could take 2.1, it would be enough for the convenience of this honorable court. The connected matter may be taken up first, madam. 2.1.
2.1.
Contempt 1040. This property is on a KIDB land, my lord. Since there's an illegal construction, I had given several representation to the KIDB and
Same order.
no, my lord, matter pertains to the same illegal construction. In contempt 621, it's against a illegal construction that is put up despite there being a injunction against them. And contempt 1040, the connected matter is against KADB where they have not taken any action despite there being an order by this honorable court. If my lords could take the connected matter 2.1, 1040, page number 153. In the connected matter, my lord, 1040, if my lords could see, para number 6, it says, a perusal of the material kept on record will indicate that though several contentions have been urged by both the sides in support of their respective claim, in view of the specific assertion on the part of the petitioner that respondent number 2 KDB is not taking any steps pursuant to the aforesaid orders passed by this honorable court, the trial court and the first appellate court, I deem it just and appropriate to dispose of this petition, directing that the present petition be treated as representation addressed to respondent number 2 KIDB, who shall consider and proceed further in accordance with law after providing an opportunity to the petitioner and respondent number 2 and hearing them as expeditiously as possible and at any rate within a period of 3 weeks from today.
Reading from which petition? Which contempt petition?
1040, the connected matter. 1040, my lord, page number 153, the impugned order.
Which one? 1040. Give me
The 2.1, my lord, the serial number.
2.2. Page
153, my lord. The impugned order. Or the order which is under violation.
the order under violation.
Yes, my lord. The KIDB has been given direction to consider the representation made by me and to proceed by giving opportunity. But till date, they have not been taking any action against the respondent number 1, against the representations made
Contempt
by.
petition 1040 of 24 notice
Yes, my lord.
returnable on.
My lord, if I also could tell, in the main matter, which is connected 6.621 also, it is the same accused and they're putting up illegal construction. A notice may be issued in both the matters, my lord.
Yes, both the matters returnable on. Third March.
Much obliged, my lord.
Not either. Remove the office objection, madam.
Yes, my lord. I'll comply with office objection.
Last will be removed. Wherever left out. Before the next. Before the next.
Seal number 3. Mr. Mallikarjun G. Seal number 3. Mr. Mallikarjun G.
Keep back.
Seal number 4. Mr. Praveen Kumar Aikote.
Notice returnable on March.
Seal number 5. Mr. Keshav Murthy B.
I appear for the.
This matter
Complaint.
compliance has been
Lances.
filed and we have taken a decision considering the factual aspects as per the directions of this honorable court.
Private copy has not been served. What is against them or in favor?
My lords. The direction was for the state to consider. This matter has been listed a number of times, my lords.
Is there on record?
With liberty to challenge Malad, it can be disposed. This is page number 75, Malad. These petitioners are the D group employees.
There was sought representation for requesting to pay equal pay for equal work.
Page 3 of the compliance affidavit, my
So
lord.
it is over, so you can challenge it. The only direction of learning single judge in his order dated 4th July 23. Was to direct number 1, 2, 3 authorities, who are the competent authorities to take decision regard to the claim of the petitioner for equal pay for equal work. The matters were remitted to the state government for taking such decision, for taking decision separation in accordance with law. Whereas in response to the contempt petition, learned in response to the contempt petition, affidavit of compliance came to be filed by the respondent state, no attention of which was invited, attention to which was invited, attention of the court to which was invited by learned additional government advocate Srimati Nilo, Srimati Pramodini Kishan, or more particularly to paragraph 6 thereof, which mentions that pursuant to the order from endorsement of the order dated 12/9/2024 has been received by the Bangalore City by the Commissioner City Corporation, Bengaluru. The said endorsement besides the representation of the petitioner and for the reason stated, the claim for equal pay for equal work has been rejected. Full stop. The above decision marks compliance of the direction of learning single judge. The competition is liable to be disposed of as not surviving, it is accordingly disposed of. It is observed that if the petitioner has complainant as an grievance about the said order, public endorsement dated 12/9/2024. On merits, it will be open for the complainant to
My lord, serial
Institute
number 58 and 50.
appropriate independent proceedings to challenge the same, in respect to which, however, this court does not have any opinion.
Lord, serial number 58 and 59 are similar matters. My lord, sir, compliance has been filed.
You are appeal? Well, I appear for the complaint, but again, in my life, in
So
those
same-
cases also I have not received any affidavit copy.
So same.
58 and 59.
58. What do you put them?
Made with the learned advocate for the complainant was served with the copy of the affidavit and the copy of the endorsement, from the factum of which could not be disputed by him. Then nothing survived. So same order.
Please.
Same order, 58 and 15. Just check the date of endorsement.
Number 6.
58 and 59.
Please, my lord, 58 and 59.
58 and 50. Yes.
Serial.
Serial number.
I'm for the complaint, my lords, in this.
Number 6.
6.
Yes, my lord.
Only there, HM.
Complainant is the absolute owner of house property number 30, Khata number 144, situated at Parapana Agrara village, Begur Obli, my lords. He had claiming the right by the way of sale deed dated 6/11/2020, which is registered in Bomnali sub-register. After purchasing of the property, has rented out the same in favor of his tenant.
The order you are complaining of.
that they have not complied.
Which
but
order? Page
Order,
Page
as
12
the-
or page 12 or page 15 or both?
Both order, my lords.
It is interim order.
Interim order, my lords. In that, they had been directed to hand over the key of the property to the complainant, my lords. Still, they have not complied, my lords. Within 8/11, they had to hand it over, my lords. Still today, they have not handed over the position. The complainant and their family are out of the house, my lords.
It is the order dated 6th November 24. Granting aid interim leave to the petitioner. Directing the respondent to redeliver the physical possession of the property. From read with order dated
6/11.
30th August 2024. Extending the aid interim order from which are made subject matter of the contempt jurisdiction of this court under the Contempt of Court Act 1917. The said interim order is passed in pending repetition number 2388 of 2024. Admittedly, the orders are interim order whereby aid interim leave granted. Rate is fixed for listing of the matter, which is 26, listing of the matter, and the petition is pending. This position could not be disputed by learned advocate of the petitioner, Mr. So-and-so. When the orders are interim in nature, and the parent proceedings of the writ petition are pending to follow on a single day, it could be said that the rights and contention of the parties are open at large, including the complaint of non-compliance before on a single day. When the rights are not crystallized, rights are not crystallized finally, this court is not inclined to invoke the contempt jurisdiction, leaving it open for the petitioner to work out its rights and remedies for the in the proceedings of writ petition, full stop, without going into any aspect of merit. The contempt petition is not entertained on the sole ground as above. Next.
Number 7. Sharavana, yes.
Notes appear for complainant in this case, my lords. Notes annexure B, page 21 notes is the order of the learned single judge. So order is dated 1/12.
Notice returning along 14th March.
Number 8.
Elections have not
Agreed out.
for almost 8 months, despite there being a direction by the single judge. The direction, the order starts at 15, the direction is at 19. Para 5 for a moment. Reasonable period was given.
Which paragraph? 6.
I beg my lordship,
Which paragraph?
I was not able to hear.
Which paragraph?
Para 5.
5.
Please. Para 5. Could I read that aloud?
So what is the contempt?
Now, this directions have been issued on 24th July 2024. Reasonable time frame was fixed so that the election process could be commenced. Circulars mandated that these elections had to be commenced on and with effect from 6/6/2024. I can just point out to the circular date, my lords. If my lordships could just take over to page 269 for a moment. This was the genesis of the mandamus. At 274, my lords, the English version, at 275, I'll just point out, my lords.
What happened, my lords, was the elections was poised to be held on 28/4/2024. Due to the parliamentary elections, my lords, the code of conduct came in, because of which, my lords, the elections were deferred till 6/6/24. My lords, on 5/6/24, my lords, the state issues a circular, which my lordships will see at 269 for a moment. And the English version, my lords, at 274. There, my lords, they said it will continue where it stopped with effect from, my lords. Might I take, my lords, to 274 for just one moment.
56 of the order passed by the under single judge, my lord. That's given permission to continue with the existing management committee and to hold elections. At that time, my lords, why the elections have still not been held. To ascertain, my lords, why the elections have still not been held, my lords. But there is an existing management committee, my lords, which is taking day-to-day affairs, and this is a condition imposed by the under single judge, my lords, that not to include in any financial decision and policy. My lords. I'll ascertain why the elections has not been.
They are complaining that you are not holding election.
Please, my lords, I'll ascertain, my lords. A short time, may give my lords, why I'll ascertain why elections have not been held, my lords.
No. These are elections. They have to be held immediately. It is not for the court has not in so many terms prescribed timeline, but then this matter will not go into it. Will not consider that aspect. You have to hold the election.
Please, my lords.
When you are going to take instructions?
2 weeks time, my lords, I will
No.
ascertain and I'll.
No, you come tomorrow or day after tomorrow with instructions.
Next,
Within what time you are going to hold election?
next week, my lords. Next week, my lords.
Not next week, day after tomorrow. 10th at the best.
Yes.
10th. Despite the directions of learned single judge, the elections are not held. The order to hold election was passed as back is on 24 July 2024. Although no time limit is prescribed, it is incumbent and obligatory on part of the authorities to ensure that the timely and speedy and that the elections are held timely and swiftly. Full stop. Learned additional government advocate, paragraph. Mr. So-and-so shall take instructions from the competent authority to specifically make a statement before the court as to within what time the elections to the managing committee of the cooperative society concerned shall be held by the authorities.
Please.
For this purpose, to be listed at 2:30 on 10th of
Please.
February.
December 9.
Notes appear for complainant notes. Annexure B, page 16 notes.
Notice returnable on
Please.
14th March.
Seal number 10. 80 Malya.
This case, the tenant, they have been ousted illegally during the subsistency of tenancy. And having aggrieved, have lodged a complaint before the police, jurisdictional police, on 27/6/2024. And my complaint was taken, then acknowledgement has been given, as can be seen from page 38. Page 38. It has been acknowledged. After that, no action was forthcoming. No action was forthcoming. Then I approached the Honorable High Court and then sought for appropriate relief. And the court has passed, the learned single judge has passed an order on 23/9/24, wherein it's clearly stated that the police have to inquire into the matter and preliminary inquiry has to be conducted and action to be taken in accordance with law. After that, after the order is passed, still no action was forthcoming for 30 days. During this time, my entire machinery has been looted and I have been thrown into the streets. I'm aged 75 years, having lost my only son. I was thrown into the streets. There was no way out for me to find out any relief. See, they are inordinately delayed taking any action.
Therefore, having left with no other option, I filed this contempt petition. Much after that, I again reminded them that by another complaint. That complaint was taken, but still no action. FIR has been filed, but still no action has been taken.
Or learned advocate, so and so for the petitioner complainant and learned additional government advocate, Mr.
1 and 2 methods.
What is your good name?
SH Raghavendra.
Raghavendra.
SH Raghavendra.
SS Raghavendra for the respondent number 1 and 2. In this contempt proceedings, what is alleged is in this contempt petition, the contempt is alleged in respect of breach of directions contained in order dated 23rd September 24, on a single judge. First of the direction in that order required is number 2, the station house officer, India Police Station, Bangalore, to conduct inquiry in pursuant to complaint of the petitioner dated 27/6/24. Well, the contention of the counsel for the learned counsel petitioner is that the respondent 2 has not conducted an inquiry so far. From on a reading of the directions, it would become evident that no time limit is prescribed by the court for conducting such inquiry. In this full stop, in the circumstances, it is not possible to conclude that a contempt of court, much less willful contempt, is committed by the in not concluding the inquiry. However, at the same time, since there is a direction to conduct the inquiry and the directions of the court should not go uncomplied with, it is provided that respondent 2 shall conduct the inquiry and complete the said within 3 weeks from today, from 3 weeks from the date of receipt of the copy of this order. Failing which, respondent 2 shall be exposed to the aggravated form of contempt. With the aforesaid limited observations, the present contempt petition is not entertained and disposed.
Number 11, Mr. Ravi Kumar BR.
Notice returnable on
Counsel for the complainant.
17th March.
Obliged.
Number 12,
I appear for
Srinivas.
This 28th February. Notice.
Number 13, Mr. P. Mahesh.
17th March. Notice.
Number 14, Tanavi R.
Keep
Sim-
it.
Number 15, Mr. Srinivas K.
Hearing complaint, my lord.
You are in 15.
15, my lord.
Notice returnable on 12th March.
Much obliged, my lord.
Number 16, Mr. Sampath.
Appearing for the complaint, my lord. My lord, this is a matter regarding the Bangalore Development Authority disposal of corner sites. My lord, the complaint is a successful bidder and he paid the 25% of the initial amount. And subsequently, he was informed that there's a list over the property, my lord. And he chose to wait until the pendency of the list. And in 2022, he found out that the list has been disposed of in 2011, my lord. Aggrieved by this, he filed a writ petition 7043.
You paid the 75% amount.
My lord,
You have paid the 75%. You have paid the 75%.
please, my lord, I have deposited the 75% amount now.
Where you have stated in the petition.
My lord, Lord, para number 12.
Notice returnable on 4th March.
My lord,
Notice 4th March.
please.
Number 17,
Complaint, my lord. Complaint petitioner, my lord, having been selected for the post of civil judge. Caste and income certificate has to be validated by the respondent.
Notice returnable on 10th March.
Mr. Oblige.
Number 18, Jagdish Chandra Kamath K. By 18.
Keep there.
Number 19, Ranganath S. Jois.
I appear for the petitioner, my lord. The under single judge has passed an order at page 18 to grant the
Notice
seniority
returnable.
to the applicant and fixation of pay.
Notice 20th March.
Disposed number 21, PAL, Mr. Gokakar Ravi Kumar.
Yes, the land in question was granted for the purpose of setting up sugar industry, research industry, way back in the year 2004. And condition of allotment as per the Annexure A was within 2 years. Till date, they have not done. And instead, they have set up the industry somewhere in the city limit itself. I produced the photographs showing that.
On a different land.
A different land. So they are not in the need and necessity. This land was used for the pasturage purpose by the villagers.
Notice, find out. Notice returnable on. It was the order of issued 2004.
Please.
2004, but it is not used. And they want that this should be a Gomal land.
1 and 7, they have highlighted conditions of allotment.
Notice returnable on. We find out what is the position. We'll say 6th March.
Please, oblige.
So number 22.
This matter I am for
PAL.
petitioners, my lord. Let the petitioners, my lord, are the villages of Uchingidirga village. My lord, wherein, my lord, there was a construction of the Ishwara temple along with the chowdhury and for the purpose of the facilities of the entire village to perform the marriage and naming ceremonies and other religious functions, my lord. My lord, the respondent number 6 to 8 herein, my lord, they are squatting over the property, and it is evident the fact that I have produced the photographs also, my lord, and I have produced the RTC, wherein, my lord, it is clearly disclosing that this land belongs to the government. But though we have given the representation to from the PDO of Panchayat, including the Tahsildar, Assistant Commissioner and Deputy Commissioner, including the Chief Executive Officer and the Chief Secretary, even then, my lord, they are not ready to take any action against the persons who have encroached the land land of the government. And moreover, my lord, they are not allowing to even to go to the temple of the Ishwara temple to the entire villagers. So that is the reason, my lord, we are before your lordship, my lord. And I have produced the photographs to that extent also, my lord. That your lordship will get at page number 79, Annexure E. And it is clearly depicting the name of the earlier Deputy Commissioner, which was built in the year of 1930 itself.
Some temple is there.
Yes, my lord, Ishwara temple is there in the first 79 page itself. My lord, they have locked the temple. They are not allowing the petitioners villager to go to the and to even pray that even temple also.
Where is the temple?
Annexure E, first photographs itself, my lord. Annexure E, page number 79.
First photo.
This is the temple, my lord. First.
So where is the encroachment?
My lord, kindly see in the next photograph where your lordship will get at Annexure 81 in the bottom, my lord. In the left, my lord, the temple is there. This is the encroachment, and now they are using this land.
The house is houses.
Yes, my lord, house. That is built for Chautri, for the purpose of performing the religious functions of the temple of the villagers. Since respondent number 6 to 8, my lord, they are very strong in the executive front also, my lord. They are not allowing to perform any functions of the entire villages, my lord.
Yeah, adjournment time.
The grievance with the grievance and the grievance and prayer in this public interest petition from IS was submitted by learned advocate Mr. So and so for the petitioner is to take steps, is regarding taking up steps against the encroachers. Allegedly this number 6 to 8, who are stated to be squatting over the property in question. It is stated that there exists a temple of
Uchangi Durga village, my lord, Ishwara temple.
Ishwar temple.
Ishwara temple, my lord.
At Uchangi,
Uchangi Durga, my lord, village.
the name of the village.
Village, please.
At the Uchangi Devi village. And that the private parties have been encroaching the surrounding area where the structure of the temple is situated and that they are not permitting the local people to utilize the temple and the area. The revenue records produced along with the petition show that the state lands are number 541. At measuring 35 mutas.
Yes, 35 cents, my lord. That is
shown in the name of government of Karnataka.
Yes, ma'am.
And Ishwara Devasthan. And in the column of other rights and obligations, the rights of Ishwara Devasthan.
And in column number 11 of the RTC, it is clearly shown, my lord.
The photographs are produced to depict the temple and the enclosed area. Notice returnable on
please
13th of March, learned additional government advocate Srimati Nilofar Akbar accepts notice. She shall take instructions and shall consider filing of the complaint.
Grateful.
Before
Please.
the next day.
Grateful.
Third holiday. 13th March is holiday. 17th March.
Please, great.
23 is urgent. Seal number 24 is a green bench matter. Mr. Satish DJ.
Let's say here. Let's say challenging the order passed by the 7th respondent, who is the Tahsildar, which is page number 141, below annexure T. That is the order passed by Tahsildar with respect to the prohibition to enforce under section 145 in the mining lease in favor of the petitioner who has granted on 19/2/2024 with prayer that the joint survey which was conducted by the very same Tahsildar, he is inspected the spot. He is saying that there is no trees and standing trees and there is no building and there is no cultivation of land. He's issued an order. He is only saying that one Rudresh has lodging a complaint. On that basis, passing the impugned order for prohibition to execute under section 145 of CRPC. Kindly see 146, my lord, page number is the operative portion. 145, my lord. The impugned order came to be passed on 16/7/2023 on the basis of the Rudresh has lodged a complaint, and another, my lord, the report has been submitted by the police, my lord, which is prior to the 2024. The impugned order came to be passed on 16/7/2023.
Where is the impugned order?
Please, my lord.
Where is the impugned order?
The impugned order, my lord, page number 145, the operative portion. Translated.
What does it say?
Right, he says that, my lord, the one Rudresh has lodging the complaint. He is saying that the through passing my land, he is the survey number 54 who is the granted in mining lease in favor of the petitioner. Right, and also the one report has been called for. The report is submitted by the police. He is saying that some quarrel in between one Rudresh and son of the petitioner. On that basis, he is the passing the orders. But 145, my lord, kindly permitted to read. There are chances of galata and disturbance of the peace of law and order in respect of disturbed land measuring 2 acre 12 guntas and village residing the disputed 2 acre 12 guntas in the village. Therefore, in the order to maintain peace and law and order to till land dispute resolved, Mr. So and so Tahsildar Taluk Magistrate Nelma Nagamangla Taluk Kasba Hobby hereby pass prohibition order under enforced under section 145 dated 16/7/2024 till further orders made. The very same Tahsildar, he has conducted the joint survey. He is saying that, you know, there is no private land is access into the adjacent to the mining lease land. There is survey number 54. Which is contrary to the joint survey report. He is passing the order. Page number 90. Make the mining lease was granted by the fourth respondent 19/2/2024 in favor of the petitioner.
So what is to be agreed?
Please,
how we are agreed? They said that maintain law and order and.
Right, I am obtained the order from the fourth respondent for mining lease as permission has been granted on 19/2/2024. Thereafter, the Tahsildar has passed an order to saying that is a prohibition not to interfere and mining lease was stopped.
What is the ground for
Please, my lord, kindly see.
extending the breach of public order?
Lord, page number 90 may kindly see.
Not coming out in the order.
Well, prior to the lease was granted in the mining, my lord, page number 90, joint survey report has been conducted with the very same Tahsildar. He is saying that there is no standing trees and building and there is no cultivation of land, which is contrary to the.
Somebody has given complaint.
Well, somebody, one person, Rudresh, is lodging the complaint. He is making the complaint.
Who has made?
One Rudresh, my lord, who is the same village.
What is the complaint?
No, the complaint is not stated. No.
My lord,
But
the
even
complaint
reference is
that,
also not.
my lord, the petitioner is quarrying in the land of Mr. Rudresh. And now what has happened is the petitioner's son and grandson, my lord, they have created there was an incident, my lord, because of which two FIRs have been registered. So now the Tahsildar, by virtue of this order, has called upon the petitioner to resolve the dispute in order to enable him to proceed with the quarrying. Until then, my lord, section 145 CRPC has been imposed to avoid any law and order problem.
144.
145.
Doesn't appear to be inspired. I'll reply.
I will.
Prior to that, I will obtain the NOC from the competent authority. And joint survey was conducted by very very.
Using somebody else's area, then you can, this person.
Right,
suspend.
my lord, there is some hitch in this. I don't know what that is.
Notice written.
Please, madam.
Immediately you
Please.
filed 13th February,
My lord, that's.
little longer, 20th February.
Much.
Reply
25.
shall be filed before the next.
So 25 is attendance. Number 26, Mr. Prakash BS.
Petitioner, my lord, was granted a quarrying lease for ordinary sand, my lord, for 5 years. Within 4 months, my lord, they cancelled the lease stating that he has not started the work. Sub-rule 1 of Rule 6 and Sub-rule 3 of Rule 6 has been violated, my lord. It
Appeal
is
is-
totally in contravention of the rule.
Appeal is available or not? It's page 20 or. Appeal or
It's,
revision?
no, there is no revision for this, my lord.
How?
There is no revision. It's a sand quarrying lease, my lord. It's a sand quarrying lease. The member secretary has passed the order on the basis of the recommendation of the task force committee, my lord. I am not seeking for restoration of the lease, my lord. Only thing, he has made a deposit of 11 lakhs and a bank guarantee of 1.50 lakhs. That needs to be returned. That is the only thing we are seeking for, my lord. There is no unjust enrichment. We don't want to seek for restoration of the lease. Within 4 months, they have cancelled. If any due has to be paid, they can collect from us, my lord, no problem. Only thing is the legitimate amount that is paid by the petitioner, my lord, by way of deposit. That only we are seeking, my lord.
What is Rule 31Y?
My lord, whole picture.
So you are supposed to fulfill certain conditions on installing cameras and web reach. For which notice was given, you did not respond, therefore this order is filed.
Final notice.
We have responded, my lord. It is responded. Rule 6.3 is violated. Rule 6.1 is also violated, my lord. It states it gives 1 year time to start the quarrying work, my lord. 1 year. And if it is started and discontinued for 1 year, they may levy a penalty, my lord, but they cannot cancel the lease as such.
You fulfill this condition. This installation of.
No, now it is expired, my lord. Now the lease is expired. Now they are not granting any leases. It is only through public auction, my lord.
My lord, the
We are not
security
seeking for
deposit
restoration of the lease, my lord.
You want only the deposit back.
Deposit and the bank guarantee that what we have paid, my lord.
No, my lord, it's forfeited. And that endorsement, my lord,
Bank guarantee also.
bank guarantee, he hasn't given bank guarantee. My lord may see the endorsement at page 26.
Because before forfeiting, my lord, they
Notices
have
were
to
given
resort to
and it
Rule
was
6.1, my lord.
Page 26, annexure D. Notices were given, final notice also given in 2018. There is no response. My lord, 2 years after issuance of the final notice, my lord, this endorsement is issued and this endorsement is not challenged.
No, the response was given immediately on the same date, my lord, seeking more time to install the wave bridge, etc. Kindly for a moment, my lord.
Supposed to release the bank guarantee or not, once the amount is forfeited.
My lord, that I'll have to seek instructions with regard to the bank guarantee, my lord. I don't know whether bank guarantee has been furnished.
Bank guarantee has been furnished. I produced this thing also, my lord. Proof of it also. Receipt, copy of the receipt. We are not worried about the bank guarantee.
What I am told, but as per the endorsement, page 26, my lord, it has been forfeited. I don't know whether the bank guarantee has been encashed.
It is not. My lord, basic.
You are not pressing upon prior A.
Not for the lease, my lord. Deposit and the
See,
bank
your
guarantee.
prior A is for setting aside entire annexure A.
Yeah, my lord.
That is cancellation of lease.
Cancellation of lease.
Now you are not pressing for it.
Not pressing for it.
You are asking only for the second prior.
Consequential, yes, my lord. Madam. Because rule 6 may kindly be seen, my lord, for a moment.
The security deposit is forfeited under which rule?
My lord, we have, my lord, as per the, my lord, as per this rule, 31Y9 of the KMMCR Concession Amendment Rules 2016.
31 by 9.
Yes,
9 to,
Roman 9.
there is no 9.
Page 411 in this book.
411.
KMMC Amendment Rules 2016. Why 9? My lord gets it.
Now his lease was cancelled for some violation.
Pardon me, my lord?
Lease was cancelled for some breach of condition.
Breach. They did not install the required cameras.
So that is what I am saying, my lord. 1 year time is there. If my lord would kindly see rule 6(1), my lord. May I read, my lord? Where the holder of acquiring lease or acquiring license fails to undertake acquiring operations for a period of 1 year after the date of execution of the lease or date of grant of license, or having commenced acquiring operations has discontinued same for a period of 1 year, the acquiring lease or the license shall lapse on the day of the period of 1 year. So there is 1 year granted, my lord. Within 1 year, we can start the work, my lord. Provided that the competent authority may on an application that is not relevant for us, my lord. Rule 6(3) says, my lord, in case of breach by the lessee or licensee or his transferee or assignees of any of the conditions specified in these rules or in the acquiring lease deed or the license, the competent authority shall require by notice in writing the lessee or licensee to remedy the breach within 30 days from the date of notice, and if such breach is not remedied within such period, the competent authority may levy a fine of rupees 25,000 in case of non-specified minor minerals and rupees 50,000 in case of specified minerals. If breach of any of the conditions specified in the rules or in the acquiring lease deed or license happens for any subsequent time, the competent authority may levy fine twice for the second time and thrice for the subsequent time as mentioned above. So therefore, here the power of terminating the lease does not arise, my lord. One. Second thing is 1 year period is granted, 1 year period is there, my lord, for the lessee to commence the work. Here, even before commencing the work, my lord, he has to make arrangement for the roads and other things, my lord. So therefore, in 4 months they have cancelled. We are not seeking for restoration of the lease, my lord. We are only seeking for the amount that we have paid as deposit, that is 11 lakhs and 1,50,000 rupees in the form of bank guarantee, my lord.
My lord, please see annexure G, my lord. It is a notice That is also, of course, a final notice that was issued on 2nd April 2018. My lord, then annexure J, another notice, my lord. That is also a final notice dated 26th April 2018. My lord, when there was no response, my lord, this endorsement is issued on 12th November 2020.
That is without jurisdiction, my lord. They could have levied penalty.
Two prayers are made in this petition filed under Article 226 of the Constitution. Extracting from the prayer clause and small Roman 1 from page 14 bracketed portion. To quote was selected. Then Roman 2 bracketed portion, small Roman. At the outset paragraph, after quoting learned advocate for the petitioner, stated that he has instruction from the petitioner not to press prayer small Roman 1 above. In other words, the challenge to order dated 10/5/18 passed by the senior geologist, Department of Mines and Geology, Haveri, is hereby given up. Full stop. Permission accordingly, paragraph the petition would survive for the prayer small Roman 2 into bracket only, which seeks the directions against the respondents to refund the security deposit of rupees 11 lakh and the bank guarantee of rupees 1,50,000. The said security deposit and the bank guarantee were the said security deposit was paid by the petitioner in relation to grant of co-release, which however has been cancelled as per aforesaid order dated 10/5/18, the challenge to which is given up by the petitioner. Notice paragraph returnable 1. This is the only thing we'll 11th March.
Please.
Obliged.
Seal number 27. Mr. Nityananda Murthy. Number 27.
The previous occasion also, my lord. Previous occasion, there's an order from this honorable court. They have not been appearing in the matter, my lord. The demand notice.
Keep back point that. You'll see in the second half.
So writ appeal matter, seal number 28. Mr. Shirish Krishna.
Appear for the appellant, my lords, in the writ appeal.
Delay.
Yes, my lords, in the connected matter, my lords, that is connected contempt. We have complied with the order of the learned single judge, my lords. My lords may kindly take up for ease of reference the contempt petition, my lords, which is 28.1.
This will not survive. Appeal will not survive.
I will come to that, my lords. I only limited the prayer in my appeal. I'll restrict my prayer to once I satisfy my lords that most part of the order is complied, only the limited portion I will follow.
Firstly,
My lords
the
may kindly see the affidavit in 28.1 that I have filed, my lords.
IA 1 of 24. All are appearing, heard learned counsel with respective parties. Interim application is filed with a prayer to condone the delay of 33 days. The paragraph, the accompanying affidavit explains the passage of time leading to delay to the aforesaid extent. Full stop. Sufficient cause is made out from the ordinance. Delay is condoned, application is allowed. Delay is allowed. Everybody is appearing.
Yes, my lords.
Now, what is the
In
all response?
28.1, my lords, I have filed my affidavit, my lords, compliance affidavit in contempt matter. If that is set, then my lords, in the contempt petition, my lords, page number 21, para 21 onwards, my lords, is the direction. I'm sorry, my lords, page 20, para 20 onwards. Now, my lords, there are 4 directions provided, my lords. We have complied with all the directions, my lords, except cost and interest, my lords. Why? Because the reason being, my lords, arrears are paid. This is the period that the order is, my lords, from 2002 to 2011. What happened, my lords? The respondent was working in the organization of the corporation, my lords. His penalty was converted to that of compulsory retirement from 2002, but he superannuated in the year 2011. So the order of the single judge was to say, because for no fault of his, he should be deemed to have worked in the organization. Kindly consider the arrears of salary that is to be paid from 2002 to 2011. Then once he superannuated in 2011, all his pensionary benefits also must accrue to him. That we have complied, no doubt, my lords. But from 2002 to 2011, the petitions and litigation was pending, my lords, for which I'm only saying I should not be burdened with cost and interest on the principal. And pension itself, we are going to give him about 17.5 lakhs. He's got already about 30 and odd lakhs for as arrears itself. I'm not disputing all of that, my lords. We have already paid all those amounts, which I have filed in my affidavit. Kindly take my affidavit now, my lords. Page number 19, my lords, is the details of compliance along with my affidavit. My lords. Item number 1, my lords. Pay fixation, my lords, and payment of arrears of salary from 38/2002 to 36/2011. Kindly see, my lords, the gross salary is 37,41,810. After, my lords, FBF is family benefit fund and professional tax, which is to be deducted, my lords. Income tax also gets deducted. Total deductions comes to 11 lakhs, and the balance amount of 25 lakhs has already been paid. White check, my lords. All those details are there. Item number 2, my lords. We have also given him ex gratia payment, my lords, for that period of 2002 to 2011, which is not there in the direction also. Payment of retirement memo, my lords. Whenever a person retires, we give them a gift, which was a watch in earlier days. Now, no such gifts are supposed to be given. We give them some amount of 2,000 and odd, which is equivalent to that value. Payment of family benefit fund also has been given. Revision of pension, my lords. We are in the process of giving them that. It is almost in the stage of compliance, and that will also be disbursed very soon, my lords, I am told. We have also computed the pension that he is entitled to, my lords. If I may produce that for my lords' records, my lords. Whatever is the pension as per the learned single judge's direction.
Are you, what part remains for challenge?
The only part is, my lords, 50,000 cost was imposed, and my lords, the interest was also imposed. I'm only asking for, my lords, modification to that extent, my lords. Rest of the part of the order, we are in compliance. Is my respectful submission.
Where is interest?
My lords, may kindly see in the order, my lords, para 23 and 24, my lords. And the reason being, my lords, he has not worked in that organization for that period. 2002 to 2011, he did not work. Even then, we have paid him the salary and also we are giving him the pension.
That's as regards the compliance of the direction issued by this honorable court. That as permitted by my learned friend, serial number 1 to 4 may not have been complied. Serial number 5 and 6 minutes are yet to be complied. But insofar as the writ appeal is concerned, that the challenge is only to the direction issued for payment of interest. That for directing the respondents to pay interest, Lordship may kindly see that the learned single judge has assigned reasons from paragraph number 16 onwards. Twice this honorable court set aside the order of compulsory retirement. Again and again, the very same order has been reiterated, holding that the petitioner would not be entitled for salary for the period during which he was out of employment. When this honorable court has repeatedly saying that the order of compulsory retirement is wrong, and the finding recorded in the impugned orders that the petitioner would not be entitled for the salary during the period during which he was out of employment is wrong. Again, 3 times very same order has been passed, and the petitioner was out of employment for more than 11 years, but because of the illegal order passed by the appellant. Kindly see paragraph number 13 onwards.
Writ appeal number. Interest is ordered since what date?
My lords,
Interest is made payable since which date?
from 2002, my lords.
What is the amount coming?
My lords, everything, my lords, on all the amounts, including pension, my lords, comes to 25 plus 17, my lords, almost around 50 lakhs.
It's only the difference
An
of
interest of 8% for almost 13 years.
This is a payment amount towards what?
Towards arrears of salary, pension, everything, my lord, whatever due I have to pay now.
Interest they have to pay. Why you are not paying salary or paying 8 years of salary?
My lords, I'm only saying that, my lords, because for the reason that, my lords, the litigations were pending. It's not that, my lords, it had attained finality in any manner. We had challenged or they had challenged. But, my lords, we had given an endorsement which came to be subject matter of challenge. Now, my lords, we want to pay whatever is due as per the order of the learned single judge. Only thing is, my lords, the interest and the cost may be deducted, my lords. It's a fair thing because he did not work for that period of almost 9 years. And he's getting salary arrears, my lords, deemed promotion. He would have, my lords, superannuated as assistant executive engineer. We are giving him the step up pay of an executive engineer, my lords.
Some penalty was imposed.
Penalty of 50,000 also, cost of.
No. Punishment was imposed?
Yes, it was a compulsory, which
Compulsory.
came to be set aside, my lords.
The order setting aside the order of compulsory retirement was called in question before this honorable court. This honorable court allowed the writ petition, against which they filed writ appeal. They say unsuccessful in the writ appeal. They went to Honorable Supreme Court. Honorable Supreme Court confirmed the orders of this honorable court as per Annexure B, page 121. At least
which order?
Page 121 of the writ appeal.
This very order is confirmed.
No, let's order.
That was set aside. It was confirmed in appeal. And so this para 16 para 16. And then criminal prosecution also was. So it also in favor of.
After having unsuccessful malady before the Honorable Supreme Court, but yet again one more order is passed in the similar same lines which has been set aside by this Honorable Court. That has made the Honorable Learned Single Judge to impose cost and
So after compulsory retirement was confirmed, dismissal order was passed.
but after compulsory
Two
retirement,
orders were passed.
but again they passed an order closing all the proceedings.
No,
But
no,
however, denying
petitioner filed writ petition against the order of dismissal dated 1810. What is that order?
Yes, that order, my lords, which
Lordship
was
are-
under subject matter of challenge before the learned single judge, my lord. What happened was, my lords, in 2015, the Honorable Supreme Court, my lords, set aside that order of punishment of compulsory retirement, my lords, by which time he had attained superannuation, my lords. Therefore, my lords, when he has already attained superannuation, my lords, the right of accrual of salary would not arise. Therefore, we interpreted that in a rightful manner.
Two more. I am not clear. 2:30, tomorrow.
Great.
Please.
Cell number 96. Mr. S. Saravana.
Lordship, we are respondents in 96. Lordship may take 96.
Where is your opponent?
So we informed him. We informed him to be here. Yes, he has also told us that he'll be there. Lordship may take up 96.1. That's the contempt. We are the petitioners in that. 96.1 and 96.2. It's a contempt petition.
96.1 is your.
Yes.
Appearing as advocate on record for serial number 96, my lords, for the contempt matters, and as a respondent advocate for the writ appeal. Please.
My lord, I beg to represent, my lord, the respondents. There's only one, my lord, humble submission which I may make. But they are mentioning the matters, my lord. The lawyer on record, my lord, doesn't inform us, my lord. Someone else informs us. There is a miscommunication, my lord. They may be directed to, my lord, make mentionings only through the advocates on record, my lord. So, in fact, we messaged the advocate on record. Advocate on record, my lord, very humbly says no, he hasn't got the information to mention the matter.
That's what we had done, Lordship. The advocate on record has mentioned the matter to them, and they have instructed
My
us
lord.
already prior given the communication. The Lordship, the matter.
My lord,
Simple
the
matter
serial
is-
number 90.
You should inform him in advance. That is
Yes,
the grievance.
My
we
lord,
informed them in advance. We have email copies as well.
My lord,
We
serial
email
number.
proofs as well that we have informed them in advance. The Lordship, the simple matter is
My
they have
lords,
submitted
serial number
certain-
96,
they have
I'm
certain,
appearing as a advocate on record, my lords. I am the advocate on record. There is no clear instructions from my clients regarding this matter being listed at 1 o'clock, and a special mentioning that is being made at 11:30. So there is a lot of confusion that has been created, and we are unable to coordinate and inform the other side as well.
Lordship, the simple
And
matter
the
that
matter of fact is, my lords, the respondents have informed me that it is at 1 p.m.
there's
So
certain
there is,
affidavits. Lordship, you see the previous orders, Lordships.
My lords, then, my lords, my humble
The
submission would
previous
be,
orders,
if the
Lordships,
advocate on
there
record
have
is
been,
saying,
there have been made.
if the advocate on record, my lord, is saying that he has no
that
instructions,
they
I
will
don't
pay
know
us
why my
4
learned friend
crores
is arguing the matter.
till May 2024, but they till date has not paid us anything, Lordships. In contempt, they have given an undertaking that they'll pay us 4 crores in May 2024 and by the vacations, but they have not made any payments till date. They have submitted an undertaking themselves that they will pay us 11.6 crores as per their own affidavit in April. Lordship, may please have that affidavit of 1st of April 2024, Lordships, submitted by the respondents themselves in 909.
96.1. You will be, you are not in the court, Mr.
My lord, the advocate on record, my lord, today is saying he has no instructions from the client. I don't know, my lord, how the arguing counsel, my lord, is making all these submissions.
But then you did not inform him.
I informed him, Lordship.
No, my
There's a-
lord, in fact,
there is a
from
email that is
advocate
to
on
the
record, there is no instructions to us, which is being confirmed by
there
Mr. Reynolds, my
are,
lord, who is advocate on record.
The clients are here physically. They have given the instructions physically as well.
My learned friend who is arguing, my lord, I don't know, my lord, if he has valid authority to appear before, my lord. I should not be making this comment because in the teeth of what Reynolds is saying, Reynolds, my lord, is advocate on record. There appears to be, my lord,
But
some
the
misunderstanding between
advocate
the
on record
lawyers.
was with her, was with us. Yes, Lordships. The affidavit of 1st of April 2024, Lordships. There's an undertaking given by them.
In writ appeal, you are appearing for whom?
So I'm the respondent in writ appeal.
You are the respondents.
I'm
Okay,
advocate
the
on
advocate,
record
so the advocate on record is stating that he has no instructions to go on with the matter.
Lordships, I got an instruction. He was here yesterday.
My lords, I am
Matter
appearing
was,
here online, and I do not have clear instructions that I have to,
the matter was listed
about
yesterday.
the advocate who is appearing. They have not got us in touch with the advocate who is appearing there. My lords, we request for a date, my lords, to clarify
clients are
what
here.
is going.
Now, what is the difficulty now?
Lordship, there is no difficulty. The only thing that
You are arguing on whose behalf in which matter?
in 96.1 and 96.2 on behalf of the complainants and in,
Complainant, one
yes,
second.
Lordships. Lordship, may please have the orders, previous orders.
96.1.
Yes, Lordships. Please have the
96.1.
909 of 2023.
So advocate on record on 96.1 is Reynolds D'Souza.
Please, my lords.
And in 96,
Appearing on the
96, what is your good name?
Anshul Gupta. Anshul Gupta.
So, are you on record?
No, I'm not on record.
You are a senior advocate.
I'm an advocate. I've been instructed by the.
You are a senior advocate.
No, sir. I'm not in senior.
Not. So, are you on record?
Lordship, not on record. I have been given instructions by the.
We do not know. That is not our domain at all. You solve your problem of filing Wakalatnama. And then come. We don't.
Sarvana is absent.
Who is Sarvana? Who?
Sarvana.
So you file your Wakalatnama or not?
Lordship, we have all the Wakalatnama signed. It has yet to be filed.
Then
We
My
have all
lords,
the.
the clients have not said anything about, the.
But we
issue.
have the instructing
There is
council.
no instructions given.
Council has been
Without
instructing us.
Wakalatnama, unless you are a senior advocate, we will entertain. Otherwise, it is your problem. Your problem. Who is to appear on whose behalf? Whether no objection is given, not given, Wakalatnama, file, not file. We are not wasting our time in all these petty matters. It is a matter between you and your client. Come properly. All the matters are all 96, 19, 96 is adjourned. Since there is no clarity about the appearance of on behalf of the petitioner, from a stand over to
Any date in March, if possible, end of March,
27th February.
please. 27th February. All right.
Please, my lords.
Lordship, can it be 28th or first?
28th.
28th. Much obliged.
Yes.
Apologies for the inconvenience, my lords.
You also do the necessary, Mr. Mr.
Please, my
Renaud.
lords, please. There is no clarity from the client's minutes. That's the reason we are
In
unable
your
to.
mind, there is a clarity or not?
About the engaging another council and there being any relation between us, there is a communication gap, my lords. That's the.
Yesterday, Renaud was standing with us, he was sitting with us all through the matters, he was speaking my senior about everything.
We were present, my lords, but.
We do one thing, tomorrow 11, we held a mediation about who is appearing on who. What is nonsense this? We are not concerned with your disputes, Mr. Counsel. And you are just interfering with.
We are thankful for Lordship's
Don't waste time like
indulgence.
this of the court. Yes, next.
This is number 29. Charlie Shantap.
Delay of more that 160 days
Delay.
in April more that.
Delay of hand, who appears?
That BDA is appear more the BDA but that party is BDA more that and land acquisition officer and chief secretary of the urban development authority.
Notice is not come.
Notice are not go.
No, no.
It is returnable on 6th March.
Please mother, please. Mother.
Respondent number 3, I will appear.
Learned additional government.
Respondent number 3.
Accept notice on behalf of.
Please.
Respondent number 3.
Please mother,
The rest shall be solved. Yes.
please. Mother.
Number 30, Sharon N. Majge.
So again, notice will have to go. Notice will have to go.
Not there. My friends are already on. They have filed the caveat.
Only party,
Vijay Tar Nayak.
no other private party. Who appears?
Not there. Kindly take page 28.
Counsel for the appellant, my lord. Counsel is not feeling well today.
Only for a short.
My lord, any day we posted not slight inconvenience. Counsel is not feeling well. I'm a proxy counsel for.
You are for whom?
For appellant. For
You are for
Vijay
appellant.
Naik, Monesh Kumar, Vijay.
Respond. No, one
Respond.
Respond, not for parent. Vijay Kumar Bandare.
I'm for Vijay Naik. Vijay Naik and Monesh Kumar.
Advocates.
No, the party is only respondent.
Yes, ma'am.
So you are appearing for or not? Only thing for the purpose we are asking, shall we condone the delay of 39 days?
I have been instructed to appear in this matter.
So we are also asking when you are instructed, should we condone the delay or?
Delay.
I'll have to seek instructions. I am just proxy.
Only 39.
I'll leave.
Full stop. Heard learned counsel with respect to parties, IA number 24. The delay of 39 days, which is prayed to be condoned, is explained with sufficient cause in the accompanying affidavit. In that view, the delay is condoned. Application is allowed. The writ appeal shall be listed on.
My lord, a short time, any time. Only short, one short point is involved.
We have complied the order past 24th February.
Please,
24th February or earlier you want
20th,
18th February.
18th.
Urgent seal number 32 to Manu Prabhakar Kulkarni.
The respondents were to come back with instructions, my lords, on mediation. I think we have some good news.
Lord, we are agreeable to the mediation, my lord. The only submission I want to make for your lordship's consideration is that the mediation be restricted to the disputes arising out of this pending OS in the commercial suit. If that is settled, my lord, this writ appeal also will get settled. That is point number one. The second humble request I have, my lord, is it should be restricted to the dispute in OS number 234 of 2022. Okay, that is the main dispute, my lord. If that is settled, this will also get settled. There's no difficulty about it.
232.
234 of 2022, my lord, before the commercial court. That is where he is claiming the shares and all that one. If that is resolved, all this will get resolved. That is point number one. The second respectful submission I want to make, I put it to my learned friends, my lord, is that your lordships may consider, my lord, requesting a former judge of the Supreme Court to be the mediator. We were suggesting, my lord, whether it could be His Lordship Justice Ravindran or His Lordship Justice Bopanna, my lord. Whatever your lordship feel and whatever we are all agreeable, we have no
On both
objection.
those honorable judges, my lords, we are absolutely willing.
Any one
I
of
would,
them,
my
your
lords,
lordship may
again,
request.
subject to what Mr. Raghavan says, my lords. Possibly, my lord, Justice Ravindran, given the commercial nature of the matter, my lords, may be better because Justice Ravindran does a lot of these.
I don't know. In fact, His Lordship, my lord, apart from doing arbitrations, does a lot of mediation. My lord, I had personal experience with many matters where His Lordship has weighed with the parties to settle the matter in very complex commercial disputes where there were multiple disputes.
And that's an identical situation here as
We have no difficulty. We have no difficulty. The third request, my lord, I have, and I made it to my learned friends also, my lord, I want to place it, that till this mediation is over, my lord, parties maintain ceasefire. Nobody must precipitate matters, at least in respect of matters arising out of OS number 234 of 2022 is concerned.
Is it not but natural? It is. Is it not but natural?
It is.
It is not.
It is but natural.
Yes. That is, no. I did not want to keep anything in my mind, my lord. I did not want to keep anything in my mind. I want to say it to your lordship. That's your lordships are right, my lord. So these are the only requests I have. If my learned friends are agreeable and it finds acceptable to your lordships may pass an order requesting His Lordship Justice Ravindran to mediate in the matter. We will approach him, my lord, of course, subject to his convenience and.
My lords, two sentences from our side, my lords. One, we are fully willing, my lords. Second, Justice Ravindran, my lord, subject to his time mediating would be, my lords, be perfect. We have absolutely, my lords, we submit to it. As regards not precipitating, my lords, I'm sorry. Mr. Raghavan indicated, my lords, that the genesis of the dispute for mediation will be, my lords, what is contained in that suit. My lords, it goes without saying, my lords, that we will in fact simply take time in that suit, not do anything, not precipitate anything until, my lords, the learned mediator, my lords, issues.
In respect of disputes in 234, let us not precipitate matters. Yeah, anyway, that's fair enough. I don't think, and I sincerely hope not. And I assure your lordships, my lord, we will all put our use our whatever influence we have on our clients to settle the matter.
Must say we're very grateful that your lordships will not fell from your lordships. The suggestion, very grateful for that. That's better for everybody.
Yes, my lord. Yes, my lord. It's a win-win for everybody, my lord. After all, business disputes, get on in life. This will be never-ending problem, you know.
Is there any reference to the suit in this order?
Yes, my lord, of course. That is the ground on which the learned single judge dismisses the suit.
My lords,
He says
annexure
that-
L at 329, my lords, is the suit.
In fact, the learned single judge says, my lord, that this writ petition has been filed.
No, that's all right.
I
I don't think that should come up now.
I'm
329.
not saying the single judge has said it.
No, we are in appeal over it.
I know that. I'm not saying no. Very well. Let's not get it.
Yeah, it
My lord,
precipitates.
answer to your lordship's question. Is there a
329, my lord.
Yes, the answer is there is.
329, your lordships have the
Give
plea.
it to me.
And the
329.
prayers are at 351.
Yes, my lord, there is.
No, in the order the learned single judge is a reference.
I'm just pulling. That's volume 2, my lords, of your lordship's volumes.
Kindly see page 68, my lord. 67, 68, sir. Plaint Allah. His lordship is asking as to whether there's a reference to this suit in the order of a single judge.
No.
That's what the question was. No, his lordship wants to know if there's a reference to this suit in the order of a single judge. Answer is yes. And the reference, my lord, is at page 67.
The court had an occasion to pass order on 20th, 125. Observing that, having regard to the nature of the dispute involved in this appeal and the subject matter thereof, the parties may take instructions as to whether they would opt for undergoing the mediation process to resolve the disputes. Full stop. The statement was recorded on behalf of the statement of learned senior advocate, Mr. C.K. Nandakumar, was recorded on behalf of the appellant that the appellant was willing to opt for mediation. Full stop. Since learned senior advocate, Mr. K.G. Raghavan, for the correspondent to wanted to seek instructions, the two writ appeals were ordered to be notified today. Today it was stated by learned senior advocate, Mr. Learned senior advocate correspondent 2, that correspondent 2 is also agreeable to go for mediation to seek for the purpose of trying resolution of the disputes. Learned senior advocate for correspondent 2, however, had 3 caveats.
No, really, 3 humble submissions, my lord. Not a caveat, my lord.
However, submitted that the disputes which are referable to and arise in the proceedings of original suit number 234 of 2022 pending before the commercial suit should be made subject matter of mediation. In this regard, learned senior advocate for the appellant has no objection, who stated that mediation may be confined to the disputes referable to original suit number 234 of 2022.
Yes.
Full stop. In the second place, both the sides have jointly submitted that they may be permitted to request Sri R.V. Ravindran.
Yes, please, ma'am.
Honorable Judge, Supreme Court, individually retired.
Please.
To act as a mediator, a private mediator on behalf of the parties. Full stop. It will be permissible for both the sides to appropriately to request the R.V. Ravindran in appropriate manner, please, by appropriate mode, requesting him to act as a mediator. In view of above, the subject matter, as mentioned above, is referred to the mediation. So notice will go to respondent.
No,
We will call,
we will, my lords, formally request rather
We
than, my
will-
lords, notice.
we will request his lordship's, my lord. After we get a copy of your lordship's order, my lord, we will meet his lordship Justice Ravindran and make a
No,
request.
other respondents.
For the present, your lordships may
Not-
dispense.
not
my lord.
necessary.
For the
May not
present,
be
your lordships may
necessary.
dispense it. Because primarily, my lord, it is our dispute.
Since the disputes primarily is between the appellant and respondent to Homa. The said two parties shall engage themselves in mediation. Both the appeals are adjourned.
Please.
To be listed next upon
We'll move your lordships. my lord.
upon a note filed by either of the parties.
Yes.
For the registry.
Yes.
It is jointly, it is the learned councils, the respective parties through their learned senior councils have agreed that since they are undertaking the process of mediation for resolution of their disputes as above, the proceedings of the suit, original suit number 234 of 2022 shall not proceed further. Suit number so and so shall not proceed further.
Please.
And that both the sides shall maintain, and that both the sides shall not take any precipitative action.
Yes.
In relation to subject matter during the
Pendency of the mediation.
pendency of mediation.
Yes, that's right. No.
It is so provided, full stop, so that it is our order.
Yes.
Yes.
The interim protection that your lordships, my lord, offered last time, that also please be continued.
This is,
I really
this
am.
is good enough. This is,
That is square the suit. The interim protection last time is square the, my lord.
That we will not
Failed.
do anything against the agreement.
Correct.
No, I have no objection. my lord. I'm not, of course, I can't tell your lordship. I dare not tell your lordship.
That may please be extended till the next day.
My lord, that is in your lordship's order of 21/2025.
No difficulty, no difficulty. I dare not tell your lordships I'm going to act against.
in addition to the above, the observations made in order dated 20th/1/2025. Inter-alia that respondent 2 shall abide by all the conditions of lease cum sale agreement, including condition number 11B, shall also operate.
So great.
I'm grateful.
Yes,
So very
grateful.
grateful.
Grateful, my lords. And I'm grateful, my lords, for initiating this process of mediation. Very grateful.
Thank you.
No, my lord, but for the fact that it fell from your lordships, my lord, it would have been.
My lord, serial number 83, my lords.
Thank you, sir.
Yeah, sir, we are reasonable, sir. If Ajay had this say, it would have been second sincere.
Why are you remembering him?
I'm not, sir.
He's such a human being.
He said. Ajay had his say. It would have been.
If Ajay had his say, we would have been
You would
less
have-
wealthy.
Yeah. You would have been deprived of.
230 ಮಾತ್ರ sir. Sir, 230 ಮಾತ್ರ. Now, 98. Orders.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬೇಕು ಅಂತ ಹೇಳಿ ಸ್ವಲ್ಪ
Notice ಮಾಡಿದ್ದಾರೆ. Thank you.
98 sir. Orders 98.
ಸರ್ ಮಧ್ಯಾಹ್ನ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗತ್ತಾ 230 ಮೀಟರ್ ಆಗಿಲ್ಲ ಸರ್
ಪಲ್ಟಿ ಹೊಡಿತಾ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್
Hello.
Continue.
Continue ಮಾಡ್ತೀರಾ admission?
Sir, serial number 72.
230.
ಹೌದಿದೆ. And those figures. ಹಾ, ಎಂಟಿದ್ದಂತೆ. ಅಲ್ಲ, we can say by the.
ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಡ್ಬೋದಾ?
ಎಲ್ಲಿಗೆ?
Or if it is being spoken to, at least if I can just request your lordships, my lord, for tomorrow. If the order is already dictated, I do not want to.
Today it is listed your vacation.
If I moved the court, because I got to know today, I moved the court.
They have moved application for vacation.
I'm just making one.
Order is already passed. We'll say that you are permitted to revive the contempt by filing
Grateful.
instead of press. That much.
That would suffice.
So convey to the other side.
Definitely. Grateful. Extremely grateful.
Get all. Give me first. Get all.
Lordship, serial number 118, my lordship. Kindly have it on Monday, my lordship. Serial number 118.
118.
Lord, serial number 83, my lords.
Is that 118?
Kindly have it on Monday, my lordship. Senior is in sick, my lordship. Senior is in sick, my lordship. Kindly have it on Monday.
Senior is?
In sick, my lordship. He is suffering from fever. Last 3 days he is not attended the court, my lordship.
All right, 10. Yeah, hey.
Lord, serial number 83, my lords.
10.
10.
Lord, serial number 83, my lords.
Yes.
My lords, I am for the complainant, my lords. A week's time may kindly be given, my lords. The office has raised objections on amended petition. I just have to ascertain and I'll comply it within 1 week, my lords.
7th March.
Much obliged.
Serial number 111. NG Sridhar.
Who is opposing you? Who is opposing you? And you want to submit anything further?
My lord, just one point, my lord. Yesterday, I mentioned and I just regarding the High Court rules, my lord. This writ petition, my lord, the purchaser filed a writ petition assailing the order passed by the Deputy Commissioner, which was a common order against 2 appeals, one filed by the grantee, my lord, one filed by the purchaser, my lord. And only one writ petition was filed.
That will require change of rule. Nothing to do with the merit.
Yes.
Yes, what do you have to say about this? Yes,
My lord, your lordship kindly see the order passed by the learned single judge. No exception could be taken. My lord, there is a delay of 27 years in approaching the assistant commissioner for restoration of the land in question. 27. Your lordship, my lord, this honorable court has passed judgment on, my lord, 25th November 2024. My lord, covered by judgment of this honorable court. Therefore, my lord, no exception could be taken. Your lordship kindly appreciate, my lord, land granted in the years 1972. My lord, the application, my lord, for restoration is filed on 6/6/2014 after lapse of 27 years. Therefore, my lord, no exception could be taken with regard to the judgment passed by the learned single judge. Your lordship kindly come to the reasoning. of the learned single judge at page number 9. Page number 22, para 9, my lord. My lord, in the, your lordship has disposed of the batch of appeals along with writ appeal number 2210/2023. In that case also there is a enormous delay. Therefore, my lord, in this case also, my lord, there is delay of 27 years.
But they are arguing on the basis of this Amarendra Pratap Singh.
Please, my lord.
If the transfer is in breach, then nothing will come in way. It stands void.
My lord, the 27 years delay.
If it is void, then no aspect of delay, no laches, no limitation would apply. Correct? That is the sir. So what is your answer?
My lord, my lord, that's right, my lord. As per the, my lord, I have not taken permission.
Is that breach of section 4(2)
4(2)
cannot be overcome by passage of time?
My lord, this is the, my lord.
That you have to answer.
Please, my lord, I seek one day.
Yesterday you were yesterday you were there or not? You were not there yesterday.
My lord, after some time, my lord, I'll be here, my lord. There is some matter is before I am on legs in the court hall number 15.
So that is the point you have to answer. You answer the contention. Otherwise, tell you uncontested contention.
My lord, one more thing is, my lord, he has not supplied any authority, my lord, address.
This is the authority. Several judgments are served.
My lord, he has not furnished those judgments.
Then one,
My lord,
this High Court judgment also.
What?
Ram Krishna, Justice Majmudar's judgment.
Whatever
Justice
he
Majmudar's
cited before this court,
Karnataka,
my lord.
yes, Muni Swami.
My lord, I will go through those judgments, my lord. I will address the argument.
Okay, Monday. Monday.
Please, my lord.
By the time you both of you prepare the synopsis also.
Yes.
Monday 2:30.
Please, my lord.
Yes.
My lord, kindly, with the leave of the court, my lord, I have come prepared with the synopsis.
Prepared?
Yes.
Very good.
My lord, I request my learned friend to furnish all
Fine,
those
you will
citations.
The synopsis.
All right. Monday. You did. Yeah, next.
Number 112, Rajendra KR. Rajendra KR.
112. Yes. Why it is kept at 2:30?
I represent respond number 4 and 5.
You responded. Same, Nikanti. 10th at 2:30.
Number 113, Mr. Wonkar KB. Number 113.
Tenure has come to an end, my lord. It has become infructuous here. Nothing would survive in this writ appeal also.
In the earlier matter also, write down none present when called out. In the larger interest of justice, turned out 10th February to be listed. Same order in this. We'll wait one chance.
Please, my lord.
One day will discuss.
Very
Number 114.
For the appellant.
Contract, termination of contract. Termination of contract.
Termination of contract.
Challenge in a
Exactly.
writ petition.
Lord, just a brief background, my lord. The respondent, my lord, is a public sector undertaking, my lord, PSU, central government PSU.
CPSU.
Lord, they have an installation in Mangalore Special Economic Zone. They wanted to set up, my lord, a substation, electric substation, my lord, for handling electricity. It's called a gas substation, a specialized station, my lord, which uses less space for my lord, having substation. Otherwise, Lord knows that it's something which occupies a lot of space. This is a new technology, my lord, called a gas substation. Lord, tender is called, I'm the successful tenderer. Lord, the contract had three parts. One is engineering, which forms 10% of the contract work. Then procurement constitutes 60% of the contract. Construction is 30%. Lord, so far as engineering is concerned, my lord, because it's not a off-the-shelf, my lord, procurement, I have completed the engineering, my lord, the design and my lord, of the equipment, etc., and placing orders on persons who are supposed to manufacture and supply. I completed the engineering part, which is the most difficult part of it as a concept. Then, my lord, so far as procurement is concerned, out of 60, I have completed, my lord, 51.64% of the work. I have placed orders, they are ready to be picked up, my lord, and brought to the site. Some of them have come also. Construction, out of 30%, I have completed 15%. Lord, that part, my lord, which includes the boundary wall and, my lord, for civil construction for housing the equipment, my lord, that is remaining 50%, half of the construction work, civil work is what remains. There is no dispute about the fact that I have completed 77.40% of the work that is entrusted to me. Initially, my lord, because I changed the bank, I have stated so in the petition and in the correspondence also, I had some difficulty for a brief period with regard to change of, because of changing, my lord, the bank with which I was banking. I have overcome that. I asked for, my lord, in the present scenario, my lord, what happened is that there was an access road to this site, which was going through the site of another PSU, my lord, called GAIL, Gas Authority of India. I used that, which they provided the access, I used it till that access was closed because GAIL is putting up its own construction. In that scenario, I was asked to construct a bridge so that the site could be accessed. That was an extra work. I have completed it. There is no dispute about the fact that I have actually completed the extra work, which costed 55 lakhs. My lord, they have certified, not yet paid, but they have certified that you have completed the work. This is the amount of money that is involved. There is no dispute about that fact. No, my lord, the problem is, after completion of this bridge, I have produced photographs. my lord, at page 301, my lord, for a minute, if my lord turns to page 301, ink page 301.
Mr. Sriranga.
Yes.
See, this is a matter which involves disputed question of facts. Now, you do not have a right to specifically enforce the contract as such. Now, even if you have that right, you have to get it done before the trial court. Tender matter, even if you allege breach of, for a minute, let us presume whatever you say is correct. Breach of contract, the remedy is for damages. You sue them. Now, allowing your writ petition as prayed for by you, what is your prayers? Where is your prayer?
To set aside the termination notice.
Lord, prayer.
To set aside the termination.
Page 47.
Page 47.
This is a pure question of facts. This is a pure
Lord-
question. It involves resolution of pure question of facts.
Lord,
Probably.
Lord, it arises out of a contract, my lord. There are facts involved. My submission, my lord, is most of the facts that are there, my lord, there is no dispute about the fact. My lord, kindly for a minute, my lord, I am conscious of the fact, my lord, that this is couched in the, my lord, in a contract, and my lord, factually, I have to establish. For a minute, my lord, kindly see 301. Only, my lord, my endeavor will be to point out that if I am able to bring out, my lord, arbitrariness in the action that is taken, Lord, I may have a, Lord, small window which allows me, my lord. My endeavor was only this. Kindly see 301, page 301. I have completed the extra work. This took time.
If you want, we will make an observation. You have the liberty to approach the arbitration or civil court as the case may be. There is an arbitration clause or what?
Lord, I am
Yes, there
ready.
is an arbitration.
There is an arbitration clause.
There is
Lord.
an arbitration.
If, Lord, if I'm not able to persuade my lords with regard to exercising jurisdiction under 226, my lord, I will go before the arbitrator. My lord, I was protected. I am protected till today by an interim order. I will approach the tribunal, my lord. I am even ready, my lord, with the names of arbitrators. If they agree, my lord, we will go there.
It will only giving you the, see, the interim order, you had it in this writ appeal.
Even during the pendency of the writ petition and this appeal also, my lord. My lord, ultimately, my lord, this I have.
We are constructing this particular project in the interest of the nation. It's a PSU to manufacture. What is that you intend to manufacture?
It's a hydrocarbon called toluene.
No, ultimately it's a refinery,
aromatic
petroleum refinery, my lord. I am only doing a substation for them.
Exactly.
And my lord, our operations are seriously held up
my lord,
because of the interim state.
my submission is this, my lord, they want their pound of flesh for whatever reason, my lord. The issue, my lord, is this: only a minuscule part of the work that I have to complete is left. It is not in dispute, my lord, that I have done extra work, which they entrusted to me, which they have certified. That is what I was trying to point out. There was a big bridge to be constructed. I did complete the bridge. Because it is in an economic zone, that bridge had to be connected to the road belonging to the SEZ. They have started the work much later, after filing of this writ appeal, my lord. They started the work. In fact, my lord, those photographs are there. They are now in the process of connecting the bridge which I completed to the road. If that is done, my lord, all that I have to do, I even suggested, my lord, I had asked for time till end of December to complete it. Even now, my lord, for me, it will not take more than 2 months to complete the work.
Now, on what ground you terminated the contract?
Lord, the original term of the contract was 9 months. The letter of acceptance was issued on 4/8/2023. 4/8/2023 is the letter of acceptance. Within a period of 9 months, the entire upgradation of the electrical substation should have been completed. We have given 3 extensions. The first extension was up to 15/8/2024. The second extension was up to to 22/8, which is the second.
15 days.
Every time they have
Hang on,
twice,
Nimsham.
sorry,
22/8/2024. The third and final extension was up to 23/9/2024. If this be the case, the
Now-
contract ended on 23/9/2024.
What is the extent of
So
work?
I have not terminated. It is a lapse of the contract.
Okay, what is the extent of work that has been done?
About 70%.
77.
77.4%.
You admit that.
There is no dispute about it. But
If instead of going in for fresh contract, if you can extend the.
No, my lord, my lord, we have already engaged people. They have started.
No, no.
My lord, after in between, prior to filing of the writ appeal, after the dismissal of the writ petition, we have already engaged other contractors. My lord, our works is seriously held up because of this.
So
My lord,
do you have that tender document with you
yeah,
for
we have
engaging the
documents here.
service of another contractor? Contract document.
So far, I have not produced it, but I can produce it. But not the question that should come up for your lordship's consideration is this. Not the law is very settled. Even recently, Honorable Justice Chief Justice Vide could not get it. Subodh Kumar Rathore versus the latest judgment, 3-judge judgment of the Honorable Supreme Court, very clearly lays down that in a contract where a state entity is involved, the scope of interference after termination is only where a public character is involved in my action. Number one.
Justice Bela Trivedi.
No, my lord, Justice Pardiwala. Justice Pardiwala judgment. Subodh Kumar Rathore versus Chief Executive Officer. It's a 2024.
That's at page 306, my lord. I have relied on that judgment before the learned single judge.
No, that very clearly
Page
says
306 of
that
the writ appeal.
what your lordships will see is to find out whether my action is arbitrary or not, is whether I am within the contractual domain. To terminate, if I am within the contractual domain, the moment I am within the contractual domain, everything else must be left to the civil court or the arbitrator. And my lord, I went through the grounds. There is no allegation of any malafide conduct. There is no allegation of any extremely unreasonable or arbitrary conduct on my behalf. Then, my lord, should he not sue me before the arbitrator?
Breach of condition number 6.
Breach of condition, that is all. My lord, he says he has constructed a bridge. My lord, that bridge he has to cross only before the arbitrator. My lord, the writ appellant cannot draw your lordships into factual disputes. My lord, that is not what writ appeal is meant for. My lord, here, my lord, lordships will see whether there is any perversity or patent illegality or jurisdictional error committed by the learned single judge. All that the learned single judge says. My lord, may I read about 3 paragraphs in the single judge's order. My lord, para 28, if your lordships would kindly see. Just 3 paragraphs in this single judge's order.
He may read from 25, my lord, instead of.
Well, you have read 25, so I will read 28.
That's where.
Yes, 25,
Ending.
26 he has already read, but 28,
For completeness.
28 at page 13, learned single judge's order. Lord, para 28. Upon consideration of the aforementioned facts and the material on record, it appears that the matter at hand involves a complex question of fact as to whether unfavorable climatic conditions prevented servicing the tender works, or whether there exists an alternate approach road, or whether the concept of approach road is a part of the scope of tender work, and the conclusion of the same being subjected to a detailed investigation and examination of witnesses and analysis of evidence. Furthermore, this court cannot sit in judgment on the issue of relevance of the contractual milestones or whether non-performance thereof could be attributed to the petitioner or the respondent. Admittedly, the petitioner has been suffering a negative cash flow since commencement of tender works, owing to several reasons, including procedural delays in availment of loans and in receipt of payment from other projects. However, fact remains that financial incapacity has restricted the petitioners from material procurement, and consequently fund disbursement towards attaining contractual milestones has not been made periodically. Furthermore, respondents contend that no performance has taken place on the work site since June 2024. Additionally, the petitioner has adduced a detailed affidavit along with the layout plans, drawing and site photograph in support of its contention, the merits of which can be established only in a trial. Respondent number 1 has filed an affidavit rebutting and disputing the contentions of the petitioner. Therefore, this is critical. Such disputed questions of fact cannot ordinarily be entertained by this court in judicial review. Furthermore, a conjoint reading of the terms of the contract governing the construction execution plan and clause 9 of GCC reveals that the dispute at hand is the express subject matter of the contract, and any dispute arising from the terms of the contract is to be referred to conciliation or arbitration. And then, my lord, para 34, para 34, about 6 lines above that, the second half of para 33. page 16, my lord, beginning with the word somewhere in the center, in the case at hand. In the case at hand, however, it appears on the face of it that the contract was terminated with the respondent one in.
Is awarded to somebody.
Yes, my lord. The learned single judge finally says, it appears that on the face of it that the contract was terminated in terms of the provisions of the contract. So I have remained within the contractual domain. No allegation, much less any evidence has been adduced by the petitioner to allege any mala fides or consideration of extraneous factors in arriving at the decision to terminate the contract. So in that light of the matter, my lord, parties should be relegated to arbitrator. My lord, he can sue me for specific performance or for damages, but I am ready to face that. So therefore, my lord, this is not a fit case to exercise writ jurisdiction. And learned single judge, my lord, has rightly said that.
Where is the judgment of this?
My lord, I'll furnish. Subodh Kumar Rathore, my lord.
306, my lord. Appeal memo, page 306.
The citation available is there.
Oh, is there?
Page 306 of the appeal memo, 2024 SCC online SC 1682.
In this, my lord, there is a separate heading on.
Page 332.
329 would be appropriate. Exercise of writ jurisdiction after termination. Page 329.
Lord, I am relying on para 63, 65 and 69 at page 332, 333.
No, but before that, there is a particular heading on exercise of jurisdiction after termination. But in this case, it is termination. Page 329. My lord, their lordship say, a relief by way of a writ under Article 220 of the Constitution will also lie against a termination or breach of contract where such action is found either to be palpably unauthorized or arbitrary. Before turning away the parties to the remedy of civil suit, the court must be mindful to see whether such termination or breach was within the contractual domain or whether the state was merely purporting to exercise powers under the contract for any ulterior motive. Any action of the state to cancel or terminate a contract which is beyond the terms agreed thereunder will be amenable to the writ jurisdiction to ascertain if such decision is imbued with arbitrariness or influenced by any extraneous consideration. My lord, a very detailed judgment on how to detect arbitrariness. It makes an interesting read. My lord, lordship may read it. But my lord, my respectful submission is none of the principles laid down here would apply because there is no palpable unauthorized action here. Everything was within the contractual domain. The writ petitioner is arguing on merits and on facts that there was a possibility, which, my lord, should be left after a detailed trial, which should be done. And my lord, on one last submission. This the unit where we wanted to do the electrical upgradation, we recently acquired it. It was one of the subsidiaries of ONGC. We have got it merged with us by following the procedure established in law. This unit has got the capacity to manufacture an aromatic hydrocarbon called toluene. Lord, the total demand is 650,000 metric ton in India, and our production is only 160. And if this particular unit is up and running, we can generate about 40 TMT per annum. Not that substantial saving for the nation. And because of the interim order granted by the vacation bench, we are prevented to give away the contracts to complete it. We are unable to execute operations. And ultimately, it is affecting the public interest because we are able to generate 40 TMT of toluene. For a couple of crores of claim of this contractor, why should that contract suffer? Let him sue me, if he's. I could make out that my learned friend's client must be very confident that they've got documents to establish. If that be so, let them succeed. Let them prove their case before the arbitrator. Why should public interest suffer?
Just in response, my lord, in the impugned order, Lord, learned single judge, my lord, has appreciated the fact in para 25 onwards, my lord, that they had an obligation to provide me access. And he also, my lord, recognizes the problem that that access is blocked, which has caused all this confusion. My lord, I have a right to seek extension under the contract, and I have made that request. Now, my lord, my learned friend pointed out that twice those extensions were granted. Each of those extensions, my lord, which I pointed out, they granted 15 days extension. My lord, I have been, my lord, trying before the court, my lord, to say that here is a case where the access is not there. I have been told to construct a bridge, and I have completed to their satisfaction. They have not paid me money for it. My lord, entire time taken for construction of that bridge, my lord, which caused all this my lord, trauma to us, has not even been considered for an extension. Every time twice I ask for extension, they grant me 15 days extension, which, my lord, smacks of malafides. Ultimately, my lord, when I sought an extension and said that before December I will complete the work, my lord, it is not considered at all. It is not considered. And, my lord, they give me a change order, my lord, on 21st, 21/9/2024. That is at page 270, my lord. The change order for the construction of this bridge approval, for which they have till today not paid, it comes on 21/9/2024, and they terminate the issue termination order on 24/9/2024. In a span of 3 days, they issue a termination order after having given me a change order 3 days before that. And, my lord, a statement is made to say that I have proceeded to grant this to somebody else. I immediately after this order, my lord, in 2 days' time, I was before this honorable court. And, my lord, I have had a protection ever since. My lord, initially, my lord, interim order was granted on 4/10/2024. And then, my lord, that has continued till date. And therefore, my lord, when they are saying that it's interest of the country is involved, my lord, correct, that work has to be completed. As a matter of fact, the cable from the substation to their factory, it is given to somebody else. That is not even, the work has not even started. That apart. If they call for a new tender for this 30%, it will take them another 6 months to complete the process. All that I'm asking, Lord, till today, it's not the question of making a claim against them and getting money. I have a blemishless record. I have completed till today, from the time of inception, my lord, till today, I have completed all works.
Today, the action of termination is completed. Number two, what you are submitting are the aspects not only just in the realm of contract, but it is in the realm of freedom of contract. Contractual freedom, much wider than the contract. And thirdly, contractual rights are purely civil rights, unless you point out, as Mr. Kamath is saying, a public element.
Yes, my lord. My endeavor is to point out, my lord, that the entire action smacks of malafides. And if I fall, my lord, within the parameters of para 63,
No allegation
of
malafides.
it is there, I'll show. My lord, para 63 of this judgment, my lord, where they said, of course, it is contractual, but if I'm able to show the, my lord, malafides and arbitrariness in the action that is taken, my lord, if it is their case that because of delay that they have, my lord, done this, when I have done, my lord, 77% of the work, and for which there is no dispute, minuscule amount of work is left. And I have made a request. It is not as if, my lord, it would have been a different situation if it was only contractual work which had to be completed. They gave me other works to do which I have done. At least for that, my lord, they had to consider. If they have not done it, my lord, my submission is the whole process is arbitrary. They may, my lord, they are today in a, my lord, situation where they can just issue a letter of termination. But if they have not done it, and in a my lord, manner which is based on the facts, if I'm able to show that the whole process is arbitrary, then, my lord, it does not preclude this honorable court from exercising, my lord, the jurisdiction under 226. Para 63, my lord, at page 332. But they refer to Raman Dayaram Shetty. in para 63, under the heading, my lord, meaning and true import of arbitrariness of state action in contractual disputes. In Raman Dayaram Shetty versus International Airport Authority, this court held that actions of the state in contractual matters must conform to some standard or norms, which is rational, non-discriminatory, and not guided by extraneous considerations. Otherwise, the same would be violative of Article 14 of the Constitution. The relevant observations are extracted. And there is a highlighted portion. It requires that the state action must not be arbitrary, but must be based on some rational and relevant principle, which is non-discriminatory. It must not be guided by any extraneous or irrelevant consideration, because that would be denial of equality. The principle of reasonableness and rationality, which is legally as well as philosophically an essential element of equality or non-arbitrariness, is projected by Article 14, and it must characterize every state action, whether it is under the authority of law or exercise of executive power without making of law. The state cannot therefore act arbitrarily in entering into relationship, contractual or otherwise, with a third party, but its actions must conform to some standard or norm which is rational and non-discriminatory.
Riranga, Ramana Dayal Shetty, it was a case of operation successful, patient died. At the end of the day, petitioner there, though he was successful, he did not get anything, any relief in reality.
Lord, I don't
So
want to be
don't
in
go
that
for
situation.
yeah. If
I
you
don't-
pursue this, probably the same thing will happen to you. You better go for arbitration now itself.
My lord, all that I'm, my lord, now I have been non-suited on the ground, my lord, that you have alternate remedy. My lord, it's not in dispute, my lord, that there is an arbitration clause in the contract so far as dispute resolution is concerned. Of course, the clause that they actually have is not enforceable because of Honorable Supreme Court judgment, my lord. Of course, it has to be either by consent or we have to come under, my lord, 11.6 to have an appointment done. My lord, my request is, as Honorable Chief Justice, my lord, is the authority under the Act to Arbitration Act to, my lord,
No, it is not
appoint-
the High Court. Now it is the High Court.
appoint
Now
the,
it's the High Court.
sorry. Appoint, my lord, the arbitrator. My lord, I am ready with the list of arbitrators also, my lord. If they agree for arbitration, my lord, I will go there.
Do that after dismissing the appeal.
My lord, my submission, my lord, is, my submission is, my lord, consider.
What to be considered?
Lord, my
Lord,
I cannot be, Lord,
Nobody prevents you.
we can agree on the
Lord, what
arbitrator,
happens?
we can agree privately. I mean, it need not be
No.
here. If the petitioner sends a notice nominating someone, we can discuss that.
By that time, as my lord pointed out,
Let us not
operation
expand the
successful,
scope of
patient dead.
a petition under Section 4 of Karnataka High Court Act by appointing arbitrator here. Not that should be, we should respect the conferment of
That
jurisdiction
may
by
be
statute.
conducive for him, my lord, as it fell from the court, my lord. It will be a case of operation successful, patient dead. Now, my lord, all that I'm saying, my lord, is that for all these days, from 14/10/2024, my lord, I've been protected by orders of this honorable court, my lord, which continues till today. Give me a breather of possibly 7 days. I will take recourse, my lord, to whatever remedy I have available, apart from, my lord, this 226 remedy that I have chosen to come before this honorable court. So that, my lord, I am not in a situation where I am remediless. I will take my chances either in a 9 or a 17 if they agree, my lord, being a state utility, and the fact that there is already arbitration clause is there. I have a list, my lord, they can agree for an arbitrator here only, and we can, my lord, go before the arbitrator and take our chances there. I may succeed, I may not succeed, but at least I'll have some recourse, my lord. Otherwise, the minute, my lord, I am out of this court, my lord, they will ensure that I have no option, but to only claim for damages. That is not the sole intent with which I've come before this court. I, my lord, want to complete that work because it will always be, my lord, a blot so far as I'm concerned. Therefore, my lord, I'm seeking a breather, my lord, a few days. If it is extended, it will not harm them. I will take chances. I will notify them, my lord, and move. If they agree for an arbitrator, I'll go before the arbitrator and take chances.
But I would say it's a very, very unfair submission. Lord, this petitioner is only thinking about himself. He has got, although my learned friend says he has got no remedies, he has got every remedy. He can initiate arbitration and claim for damages. Why should he hold me for ransom? Lord, why should the work stop? We don't want him to do the work anymore. My lord, we have given him 3 extensions. He has failed.
They don't
But
want
he has
me to
all
do
the
it.
remedies. My lord, please do not consider extending any interim order. Lordship may decide the appeal on merits itself. My lord, anyway, once it is decided, no interim order will continue.
That's the point. Somehow they don't want me to do it. For
Yes,
some reason.
There is no doubt about it.
We are not able to figure
There is
out
no doubt
as to
about
why.
it. I want to go on record saying we don't want to work with this petitioner.
What is operating from interim order?
Yes, my lord, not to, the interim order says not to continue with that work, the appointing.
Not to award.
Yes, yes, my lord, it was during vacation bench. Lord, it says there must not be any precipitation until the next date of hearing.
Not to formalize contract is what it says, my lord. There's a detailed order.
So why should my work suffer?
Detailed order of 24/12/2024.
Definitely against public interest. If every day's delay, we are losing out on the revenue.
What
it is 24/12/2024.
There's a detailed order. After hearing that order was passed. Hearing both parties. They were on caveat.
Yes. Grateful.
Till then, Lord, the interim order, interim arrangement. Great.
Grateful.
Number 115, Sri Vijay Kumar K. Appeal for the complainant in. I appear for the complainant in this matter, madam. On the last date of hearing, there was a specific order which reads as under, in that view, while granting time up to next date to the respondent, it is expected that direction should be complied with before the next date, failing which court may have to take a stern view. The BDA is supposed to execute sale deeds in respect of in favor of the petitioner for acquiring the land. Petitioner's land measuring 7 acres was acquired. And as per the incentive scheme, petitioner was entitled for 7 sites. And the learned single judge order clearly states that they have to comply with the order.
Lord, the learned single judge has directed us to execute the sale deed. The learned single judge has directed us to execute the sale deed for 7 sites. We have fixed the date on 13th February 2025, my lords, for the purpose of registration. And of the 7 sites, my lord, that had been directed, the learned single judge also had told that if those sites are not available, other sites may be granted. Yesterday, my lord, the petitioner was present before the BDA. 5 different sites allotment letters have already been issued to the complainant. May I place it on the different sites. The allotment letters have been collected by the petitioner complainant yesterday in the BDA. I'm sorry. I'm sorry, my lord, I did not get the time to. Now, my lord, we have fixed 13th as the date for registration of these sites. What happened, my lord, was that the sites which has been identified by the complainant, my lords, those sites were not part of the sanction plan, my lords. Since they are not part of the sanction plan,
Of the 7 sites, 5 are not part of the sanction plan. So instead of those sites, we have allotted them other 5 sites in the very same area layout where the petitioner has lost his land for acquisition. For the other 2 sites which they have identified, we are ready to go ahead and do the sale directly. So we fixed the date as 13th, my lord, for which we have also issued them an intimation. He has to come and give return his original documents, my lord, pertaining to the land, and on that day get the registration done. Lordship may kindly come to page 8 and 9, my lord. I'm sorry, my lords, I did not file the translation. But the sites which they have identified, my lord, they are not part of the sanction plan. We will not be in a position to execute them as a sale lead. They're not incorporated into the sanction plan. But we will give 5 different sites, my lord, in the very same layout. Banshankari 6th stage, where, my lord, the complainant had his land acquired by the BDA. This very same scheme we are giving the sites. We have to give 7 sites, my lord, 40-60. Total dimension would be 16,200 square feet, which we are giving, my lords. My lord, it's now approved, my lords. Lordship may kindly see the order of the learned single judge. It's approved, my lords, and we have called him. At the end, my lords, when we were about to complete the formality, we saw in the sanction plan, my lords, when we were cross-checking, we saw, my lords, they have collected the allotment. My lords, the site numbers are mentioned in the memo, my lords. Site number 149,
I have to
150.
seek instructions, man. At day's time, I kindly be given, man. I will verify with my clients whether he is satisfied or not, and I will come back.
My lords, the learned single judge order, my lords, registered deeds of sale conveying said sites if they are available as sought for by the petitioner in these state petitions, and if not available, the respondent BDA shall identify and allot suitable sites and complete the process within an outer limit of 8 weeks. So sites as identified by them are not available, my lords. So therefore, we have given them an alternate in the very same layout. Please, my lords. We issued the allotment letters, my lord. Please.
I will seek instructions and make submission. But within 2 days, I will submit. Within 2 days, I will submit. Well.
8 now. 8. Publish, my lords. Not good. And moreover, what's happened, my lord, is what our sites they have identified. They are odd dimension sites, my lord. What now we have given are proper 12 into 18 sites. So it's really up to them. It's not, my lords, that learned single judge says if it's not available, give them an alternate site. So we have done that, my lords. Publish, my lords.
Number 116.
This matter.
They
is
issued
that
the,
right?
they issued the grant certificate, my lords. They issued, as per the order of the learned single judge, now they have issued the alternate site. In respect of alternate site, now they have issued the grant certificate also. Therefore,
allotment of sites, alternative sites.
No, my lords, not the one which is mentioned in the affidavit filed by them.
My lords,
Alternative, another alternative.
They have
site.
other alternative sites.
My client, yes, ma'am. Complainant is satisfied.
With their consent, it's been allotted. Court of. This is in Kannada.
Please, my lords. Please.
Right. Please, minutes, within a week's time, minutes.
Number 117.
Complaint.
For the accused. Lord, I have filed my complaints report, my lord. With regard to that, they have filed objections. My lord, the complaints is to consider the representation, my lord, which they have given. We have considered the representation and passed the order telling that kindly come and enter into a supplementary agreement for this much of amount. We have complied the order, my lord. They have filed their objection with regard to that. The order is at page number.
Contempt of the court order, my lords. Just they refer to the writ petition and take their own arbitrary decision. This on court specifically directed, keeping in view of Annexure R and other related documents, take the decision and communicate it to me. Not even one word is said about Annexure R or the connected papers which I have produced along with the writ petition, which are their own records.
This is the contractual case, my lord. We have considered whatever he has given, we have considered. The endorsement which we have given at page number 4 of the complaints report, my lord, we have told that we have considered.
Kindly take to page 7 of their complaints, my lord.
Before that,
Instead of wasting time.
before that, we have first, page number 4 is the endorsement which we have given. We have told, we have considered everything and we have told that this proposal, whatever he has asked, is sent to the competent authority for approval. Once it is approved, then we will come back. Then later on, my lord, after we getting the approval, my lord, we have passed the orders at page number 7, telling that, okay, the competent authority has given the approval for this much of amount, kindly come and enter into a supplementary agreement. May I submit this, madam? No, if they have any grievance, this is a contractual matter. If they have any grievance, they can challenge the order. However, we have considered the representation along with the documents which he has given and then sent the same. The proposal has been sent to the competent authority. The competent authority has given the approval for some amount. That amount we have considered and we have given the reply on by on 6/11/2024 at page now, number 7.
Contempt. Kindly see page 7, my lord, of what he says is the compliance of the order. Middle paragraph. In writ petition number 24959 of 2022, wide reference number 3, wide court order dated, Honorable High Court, the case is disposed of by directing the to review and consider the requisition as per reference to. Now kindly come to the order of this Honorable Court. How they have played mischief. In page 10 of the contempt petition.
Now, it was a contractual work
Yes.
on the ground that they have done extra work and there was delay because of the action of the respondents. And they are entitled to higher amounts. Therefore, they give a representation to you.
Please.
To give extra amounts.
It was considered.
Allah, initially it was not considered.
This Honorable Court directed in another previous writ petition. Accordingly, they considered. Executive engineer certifies that 3 crore 55 lakhs is the final bill. I completed the project 5 years ago. Villagers are enjoying the water. I am denied the total amount. The executive engineer is the competent authority.
Whatever, because they did not consider your representation, you filed a writ petition.
Yes.
The priors are extracted at page number 10.
11, paragraph 5, last 3 lines, my lord.
Page number 10, the priors are extracted.
Yes, madam.
Considering your priors, at paragraph number 5 is the relief granted to you by the learned single judge.
Not even one
Now,
word is said about it.
Pursuant to it, now coming to compliance report at translated copy at page number 7.
Yes.
4 also is there, my lord.
4 also is there, but mainly the
First we consider and send for approval. Whatever is there, the document which was submitted by.
Said. Consider means.
Now their
not
contention.
oral submission.
1 second, sir. Their contention is you are entitled to an additional amount of 2 crores 58 lakhs 81,192.
Additional amount, Allah, the entire amount.
Please, my lord, he is right. My lord, the
Okay,
contract amount is 1 crore 15 lakhs, my lord. The total, now supplementary agreement we are calling. Other than that 15, total amount is 2 crore change. As per our calculation, whatever the work he has done, for that we have considered his documents and sent a proposal to the higher authority. The competent authority has approved for that amount.
No.
If he has any.
Competent authority has already certified it for 3 crore 55 lakhs.
His
long
chief
ago.
engineer is not the competent authority, my lord. He is only an executive
Superintending, my lord, executive engineer is the authority to prepare. Thereafter it goes for approval. It was sent. In the high level, for their own reasons, which I cannot explain before the court, it was not approved. Chief engineer will not go to the spot. MD will not go to the spot and see what I have done, what problems I have faced. The person on field who got the work executed under the contract to certify has certified. Not even one word is said in this page 4 or 7. It is utter contempt, my lord. They just take it casually and they think they can write anything and say we have complied. 5 years after completion of work, a contract is denied of the amount. He cannot even take another work because he has no money. He has to pay the bank.
My lord, everything will be recorded in the MBs, my lord. He has to check everything, and then he cannot tell that, yes, you have to give, as per you, it has to be given 3 crores. It has to be sent to the higher authority. That's what he has done. He is not the competent authority to approve the MB. He has done his work.
Authority did not come and assess the work. For denying him what he demands, he writes this. Kindly see in page 45 of the petition, my lord. I have given simple calculations. I have given how much amount is due.
Calculation is
What
different,
is
my lord.
certified by the superintending engineer.
Calculation is different, my lord.
You are-
My lord, what is the
Eh,
physical work which?
Middle of, on page 45, yourself had written letter to me on 18/1/2022. Accordingly, as per rate approved by the superintending engineer, schedule B bill of quantities, the total amount is 3,55,44,452.
I hereby request you. ಇದು ನಮ್ಮ representation.
ಸ್ವಲ್ಪ My representation clearly refers to their own assessment, approval, and request them to pay 3,55,44,452. And I am ready to enter into amended supplementary agreement. Right. Annexure R. That is the direction of the Son of Court. I give the succinct details so that they will take decision faster. As certified by you, 3,55,00,000 is due. That is based on letter of the chief engineer himself. Annexure R, they don't refer. Kindly see annexure. No. My lord says, where is the compliance? This all court specifically directed, consider annexure R, not to take their decision based on my representation. That is the purpose for which I had approached this all court. Please, no, referring to annexure R is not consideration, my lord. This all court will not agree for such things.
Considering
They
that
only say in both the pay letters, petition number, wait, so and so, so and so. not even 2 lines of discussion about why they do not accept the report of the assessment of the executive engineer, recommendation of executive engineer, and they also take techno-legal opinion from their own department legal advisor. He also says this has to be paid to the contractor. No reference, just a casual letter after the receipt of this notice in contempt is not compliant. Look at the direction of this report. If my lords find even 2 lines of consideration of my representation, see, referring date is not consideration. They only refer, they don't consider. Translated copy at T4. Kindly see in the endorsement sent to me, date of this on court's order, above that, your requisition dated 7/9/2022. That is the prime. Plus, entire letter or contents of this endorsement I am reading. Nowhere they discuss, consider and say, no, it is not. They refer to last 4 lines I will read to show how arbitrary they are. Considering the delegation of powers vested, a proposal is prepared and submitted for approval from competent authority, including the contents of the order passed by the Honorable High Court on 4/7/2016. The techno-legal opinions, departmental rules and regulations and your requisition aspects mentioned in letter dated 7/9/2022. The proposal was submitted, no consideration. The techno-legal opinion which they refer, if they produce it before my lord, that will expose them. I have produced in the writ and also in the contempt side. Kindly see page 109, techno-legal opinion of their own department. They say they are following it. They are going contrary to it. Page 109, their techno-legal opinion which they have taken. They only mention techno-legal opinion dated. Kindly see the total entitlement of the contractor for the entire works as per CE order and Honorable High Court order determined at 3,55,44,452 shall be payable to the contractor. Have they considered this, my lord? My representation is secondary. The cursory reference to letters, my representation. There is no consideration. consideration is only referring to the letter. May lords accept that?
Considering.
And even there, they only say, only if it is approved, only after you execute agreement, they will pay that paltry sum.
Third learned advocate, Mr. So and so, assisted by learned advocate, Mr. So and so for the petitioner. And learned advocate, Mr.
For accused, all accused, Prashant.
What is your good name?
Prashant.
Prashant, for respondent, all the respondents?
All the
All
respondents.
the respondents. In this petition, filed invoking the jurisdiction, seeking to invoke the jurisdiction of this court under the Contempt of Courts Act 1971. It is in respect of the following directions of law on a single judge passed in order dated 13th June 24 while disposing of the petition. Writ petition. Formal breach and the consequential contempt is complained of. Paragraph 5 on page 11. In view of aforesaid facts. The disputes between the parties as sought to be agitated in the writ petition were not for arose from the contract executed between them. What was prayed by the petitioner to direct the respondents to consider the representation dated 7/9/22. It was next prayed to direct respondent 1 to accept and approve the calculations provided by the petitioner. The third prayer was to direct the respondents to fix the rate of additional and substituted work carried out by the petitioner and consequently to make payment in that regard. Full stop. The petition came to be disposed of with the directions as afore quoted. Full stop. Therefore, what the learned single judge directed was to require the respondents to address the grievances of the petitioner and consider his representation dated 7/9/2022. Full stop. In response to contempt petition filed. In response to the issuance of notice, respondents have appeared to file their statement of objections from memo of compliance. There it is inter-alia stated that the respondent has considered the representation dated 7/9/22 and an order public endorsement has been passed on 6/11/24. The said copy of the said endorsement dated 2/8/24 figures on dated 6/11/24 figures on record.
I filed my objections to.
The further objections are filed by the petitioner to the said endorsement. Countering what is stated in the endorsement. Full stop. As per the said endorsement dated paragraph 6/11/24. The complainant is required to, the complainant is intimated that it may execute a supplementary agreement. For the extra work approved, which has the financial implication. Full stop. in the said endorsement, paragraph 611, said endorsement is 61124, thus response of the authority is reflected and the petitioner is requested to execute the supplementary agreement. Full stop. It is to be recollected that the directions of learned single judge was to consider inverted comma the representation of petitioner. Full stop. By taking aforesaid stand, comma, the representation is considered. Full stop. It could be said to be marking compliance of the directions of learned single judge. The contempt petition is not liable to be furthered anymore and will not survive. Accordingly, it is disposed of. However, if the petitioner has any grievance about the merit content of the said endorsement dated 6/11/24 and the stand oblique action taken by the respondent authority, it is open for the petitioner to institute appropriate independent legal proceedings, independent proceedings in accordance with law, in respect of which, however, this court does not express any opinion on merits.
This time frame may be fixed to do that, the arbitrary assessment to be.
Which
completed.
was time frame?
For litigation.
Time frame for what?
Blood, they say they will pay something 2 crores.
They have to come and approach us, my lord. That is
Not
left to
our-
them.
Same exercise will happen.
It is not our domain in contempt jurisdiction to provide all this.
Please, for liberty given, my lord, unless they take decision faster, I will not be able to approach this on court. Intended writ petition, and then, my lord, they will take their own sweet time, and they have taken already 5 years' time. Kindly appreciate. This time frame may be fixed.
Setback matters, seal number 3, Mallikarjun Ji. Seal number 3,
Serial number? Setback. None present in the second round also. In the larger interest of this, stand over to 18th March.
seal number 14.
14,
Please, I'm sorry, my lord, I could not be represented. The earlier.
notice returnable on 10th March.
Yes.
Number 18, Mr. Jagdish Chandra Kamath.
Your Lordship, I'm appearing for the complainant. I apologize for not being present in the first half, Your Lordship. Your Lordship, if I may briefly describe the dispute. Your Lordship, this has arisen out of the gross disobedience of the order passed in WP number 9175, wherein the order was dated 25th April 2024.
Notice returnable
Grateful, Your Lordship, grateful,
on 28th February.
grateful.
This is seal number 27, Mr. Nityananda Murthy P. Seal number 27,
None was present in the, this is the impetuous.
My lord, not this one, my lord. This is a matter,
None
where
present.
last time Lordship has passed an order that last time also none of
On
them. were
behalf of the
present.
petitioner in the first half. Full stop, the petitioner was called out for
There's already an order on the previous day.
second. Session when the petitioner was called out again. Some interim order is operating.
Interim order, my lord, they were permitted to operate by remitting the demand amount, my lord. The lease has also come to an end, my lord. It has come to an end. Now the interest component we might have to require.
On the last
Require,
occasion
my lord.
also, this court had an occasion to pass the following order. Last occasion on 29/1/25. Quote the order. Full stop. Learned advocate after quoting. Learned additional government advocate, Mr. Harris, was justified in submitting that while on one hand, the counsel for the petitioner has been consistently not appearing in the matter, comma, the petitioner is enjoying the interim relief. Full stop. The following directions are received. The registry shall issue fresh notice to the petitioner, returnable on Don't say that. It's a look. We give one chance and then. It's the last chance to be listed on 10th of February at 2:30.
Writ appeal matters, seal number 33, the state appeal.
My lord, there's a delay, my lord, I'll take out notice. State appeal, my lord, there's a delay. I'll take out notice, my lord. First time matter,
Notice,
please.
returnable. Notice 33, notice returnable on 11th March.
For 34, Mr. Venkatesh S. Sarabati.
The notice, I'll take out, not delay is there, not, Leonard single judge has quashed not rule 14A of the KPTCL regulation, which has been long standing for about 40 years. Similar matter, not your lordship had directed notice, same council, not, I'll take out 10th
Notice
February.
returnable on 12th March.
The 10th February is the other matter,
10th February is coming.
10th February. I'll take out same council, sir.
Written on 10th February, as it was stated that I similar appeal is.
Writ appeal 15 of 2025.
Writ appeal number 15 of 2025, which is similar to this, is going to be listed on 10th February.
Great.
35 is adjourned, seal number 36, Santosh BM. 36, seal number 36.
You for the appellant in this case. On last date of hearing, my lord, records were called for. This is regarding,
What is it about no confidence?
this is regarding no confidence motion, my lord, against the Adhyaksha of Gram Panchayat, my lord, wherein, my lord, there is serious interference by the PDO, my lord. The executive interferes, my lord. Last date of hearing.
What is the matter? Let us, what is the matter?
A confidence, no confidence motion, my lord, was moved against the Adhyaksha of Gram Panchayat, my lord.
You are the.
I am the president.
You are
I am the president of Gram Panchayat. A motion of no confidence, my lord, was moved against me. My lord, I have filed various complaints against the PDO. My lord, he's been issuing katas, my lord, to various illegal layouts. I had opposed that. So, my lord, he interferes, my lord, and he, my lord, gets issued a confidence of no motion, my lord. If you the operative, the impugned order, my lord, page number 25, my lord, ink page. Ink page 25, my lord, para 2, my lord, the learned counsel for the petitioner contends that Rule 3.1 of the Gram Swaraj and Panchayat Raj motion of no confidence against Adhyaksha and Upadhyaksha of Gram Panchayat rules contemplates that a copy of the proposed motion along with the requisition will have to be personally presented by 2 members to the Assistant Commissioner, and the notice that is now produced indicates that it was endorsed by the Panchayat Development Officer PDO, and therefore the notice stands vitiated. My lord, this was my argument. My lord, by way of the impugned order, my lord, the learned single judge says there is no substance, my lord. I have filed a memo on last date of hearing, my lord. My lord, the lordship could take the memo. In a similar matter, my lord, the Dharwad bench, my lord, has held that if there is interference by PDO, my lord.
So what is your ground?
The PDO, he has countersigned the application.
It may countersign, that doesn't invalidate the motion of no confidence.
No, on that ground, my lord, the Dharwad bench, my lord, has already held that no, he ought not to. The state has been directed to educate their PDOs, not to sign. The state has been directed, my lord, to educate their PDO. If your lordship could take the memo and last date of hearing, I filed a memo, my lord. If your lordship could take that.
Which memo?
Last date of hearing, my lord, I filed a memo. Sir.
Yes. Memo to document. What is it?
Identical case, my lord. Last page number 10, my lord. It starts. So far as this is concerned, my lord, the notice was quashed and a direction was issued to the state saying, directing them to educate their PDOs. my lord.
Now here notice of motion, one addressed to whom?
Addressed to Assistant Commissioner.
Assistant Commissioner. Assistant
No,
Commissioner.
Only
No.
the
He
development.
lost his majority, my lord. He has not lost his majority. It is only to
We are not-
identify the
we are not on
signature, he has put the initial.
It is
Video, that itself will not.
The argument is that it is wrong, presented in a wrong.
No, no.
All that he's saying is, in the application form number 1 submitted to the Assistant Commissioner, there is a sign and seal of the PDO.
PDO.
That
To
will not
identify
vitiate
the
the
signature.
proceedings, my lord. That will not
Right.
vitiate the
So that was the ground on which this writ petition on Dharwad bench, my lord, that
My lord,
What?
Lord, page 3 may kindly be seen in the same memo, my lord. I have secured the original records also. That is the same as what is
You
there in page.
satisfy us, we don't want to see record for the time being.
Please, my lord, page 3 may kindly be seen of the same memo.
Show the no confidence motion
My lord,
from your record.
this is a meeting, my lord.
Show the no confidence motion letter from your.
Letter.
Please, my lord, that is part of the record.
That's all.
What of?
This is in the petition.
apart from that, my lord,
Annexure A may
this
kindly.
this post of President, my lord, is
Annexure
reserved for
A.
scheduled tribe, my lord. I am the only candidate available.
Annexure
I am
A,
the only
page 40 may
candidate
kindly.
available.
My lord, this is the application, my lord. Page number 40, annexure A is the notice.
Address
Can
to
you-
deputy commissioner.
Please, my lord. Assistant Commissioner.
Assistant.
Assistant Commissioner. Lord, their contention is there appears a seal and sign.
Requisite number of by requisite.
Please, my lord.
Please, my lord.
No, PDO, my lord, he ought not to have done this. In view of this judgment, my lord, PDO ought not to have done.
My lord, there is a seal and sign at the bottom, my lord, of the PDO. Their case is that he should have not signed it.
If your lordship could take Rule 3.1, my lord. Rule 3.1, my lord.
Rule 3.1.
First time putting.
No conference motion. Notice is at page number 40, annexure A, my lord. That is the notice issued by assistant.
So what is it?
Rule 3, if your lordship.
Motion of no confidence.
A written notice of intention to move the motion under the proviso to subsection 3 of section 140 of the Act shall be in form number 1 signed by one of half of the members of the total elected members of.
Is done or not?
No, that is that. I am not on. Members together with a copy of the proposed motion shall be delivered in person by any two of the members signing the notice to the Deputy Commissioner of the
Is done or not?
Yes,
Done,
sir,
my lord.
that has
It is
been done.
issued by him.
No,
Somewhere it is reflected in record.
My lord, yes, my lord. Assistant Commissioner has initialed it for having received it. His signature is there on the top of that form.
my lord, my contention is that was delivered by the PDO. It was delivered by the PDO. Based on the very same argument, my lord, the Dharwad bench, my lord, he ought not to have signed it. In a no confidence motion, my lord, he doesn't have any role to play, the PDO. He's an executive. His signature, my lord, vitiates the entire.
Delivered in person specified under subsection 2 of 49. What is that, Commissioner?
Please, my lord.
Under section 4, section 14. '49 of 1993 Act.
49.
Please, please.
Subsection 2 is omitted. With effect from
2 is omitted, 49.
31,320, 31,320. And this no, this was of which?
And my lord,
But the Xerox produced by the petitioner in the memo.
Yes.
And your record doesn't match in some respect.
See,
Please.
P1 contemplates a notice being issued to the assistant commissioner
Please.
by the required number of
Members.
Okay. Now, come to page number 3 of, what is it? Who has filed it? The petitioner has filed it.
Correct.
The appellant has filed it.
Please.
Or a memo with documents. There in that, if you see the bottom, there is 2 places, sign of 2 seals of Panchayat development.
certified copy. It's certified.
Please, one additional. seal
Okay,
is-
one, it says Upavibhadigharigala Paravagi. That means on behalf of Assistant Commissioner, it has been received and signed. But in the original records produced by you, there is no evidence to show that this particular letter, though addressed to Assistant Commissioner,
Please.
was in fact served to the Assistant Commissioner because it has been received by the Panchayat Development Office.
I will explain.
No,
my
this
lord.
is
My lord,
certified copy.
What
seal.
is produced at page 3 is a certified copy, my lord,
Certified copy.
issued by the office of the Assistant Commissioner.
It's certified copy.
One additional seal is the seal of the Assistant Commissioner for
Certified
having issued the certified copy. That is what is reflecting in the appeal memo. The original, it may not be there, my lord. The third seal is not there. On the top of the original, my lord, there is a signature of the Assistant Commissioner himself for having received it. Please, my lord, that signature tallies with that of the notice signature, my lord.
PDO delivers it.
Top of it, that signature tallies with page number 2, my lord. That is the notice issued by Assistant Commissioner.
Through PDO, it is delivered to Assistant Commissioner, what?
No,
What is
my
your-
lord, it has received in person, 8 members have presented it, that's my instruction. 10 people, 10 members have signed.
We
the
have presented.
application.
You ought not to have countersigned it.
8 people.
Mr. Counsel, where is the original of your production?
My lord,
Page 3.
my lord, it was produced before the learned single judge. The writ petition, in the writ petition, it was produced.
No, this which
The certified copy of this.
which you are producing now.
Please, please,
Writ appeal.
please.
Where is that original?
It was produced before the learned single judge in the writ petition. The certified copy.
Original, we want, not certified copy.
No, original.
You must have got this Xerox from some original. Where is that original?
No. This is issued to him by the Assistant Commissioner's office.
Assistant Commissioner's office.
Please.
This is the original.
So this is the only this is the seal of assessment. So
He certifies it and gives it.
what is the illegality then?
No, PDO has signed it. PDO has signed it.
It is here also. But the endorsement signature says that it is issued by the assistant. Correct.
No, 2 members haven't delivered it. It has to be given by 2 2 Gram Panchayat members. My contention is it's given by the PDO.
We members, my lord, we have presented, my lord, 2 members to the Assistant Commissioner. His contention is the initial put by the PDO is defective.
No, that judgment
It will
which I
not
have produced,
vitiate, it's a
it says
curable
that.
defect.
It vitiates. He ought not to have signed it. What is the role of the executive, my lord, in the no confidence motion? I asked myself this question. Executive, my lord, he can't.
But he has no majority, my lord, by the technical way he wants.
And I am the only ST candidate available in the Gram Panchayat. And my lord, by virtue of the impugned order, my lord, 3 days notice has been given. Section 49 contemplates for 10 days notice. By virtue of this impugned order, my lord, only 3 days notice has been given. A fresh notice has been given to me now.
See, everybody need not go and deliver it to assistant commissioner. Rule 3 says only 2 persons are required.
Please,
But
His instructions are 8 persons have gone and delivered.
8 persons have delivered.
no, the PDO has delivered it.
That's an allegation.
Sir,
We'll consider.
No, that's my allegation is based upon the counter signature. There are various other cases, writ petition, my lord, wherein if the PDO has signed it, the notices are being quashed.
In that case, it was addressed to the,
And my lord, this violative of article,
it was addressed to Panchayat Development. That.
please, ma'am. No, even in those cases also, my lord, the very same aspect has been.
All right, we'll consider. Reserved for all.
Please.
At length, honorable party stated that they argued the appeal finally. It was stated that the pleadings are complete and no further are required to be added or supplemented. Reserved for all. Reserved for judge.
May make one, sir. I had got a protection last date of hearing, my lord, to not to hold no conference motion. That may be.
There was interim order, my lord, to defer the meeting,
Is
which we have
reserved.
deferred, my lord. That is also forthcoming in the records.
The same may be deferred until
Till
passing.
the passing of the final order.
Renewed.
Pardon, my lord?
Order is in operation, interim order.
There's an interim order which directs us to defer the meeting, which we have done for a period of 1 week till today, my lord.
Interim order which is operating shall continue.
We'll defer it, my
till
lord.
the pronouncement of judgment subject to final outcome.
Very well, we'll defer it.
Grateful.
The learned single judge had
Keeping the original for 1 day, tomorrow we'll take it.
very well, my lord. I have flagged it, my lord, the forum number
The
1.
new notice also, my lord, which I have, I've also produced along with the memo. That's the first. Grateful.
Number 37,
May I please, your lord?
Ms. Sarita L.
I'm before your lordship, my lords, on a very, very limited point, my lord. It's the respondents invited, my lords, for tender, calling applications, my lords, for wholesale transport and retail transport of various food grains. Many of us submitted our applications. One of us, my lords, was declared as a successful tenderer. No contract was awarded. It was not rejected. Perceptionally, my lords, they have abandoned it. Now, my lords, they have re-notified the tender, my lords. All that I'm saying is, without rejecting, my lords, my application, my lords, under the earlier notification, my lords, they possibly, my lords, could not have called for a fresh tender, my lords, which is straight away in contravention of Section 14 of the Public Procurement Act. My lords, under Section 14, my lords, your lordships have taken the view, either it has to be rejected or they have to pass an order, my lords, abandoning it. Now, my lords, I have to today before your lordships perceive that the earlier tender is abandoned
And my lords, they have sought for, my lords, called for a fresh tender. As an offshoot of this, my lords, only three contentions are available. One is section 14 of the Act, my lords. Second, my lords, please look at the situation, my lords. There was a committee which was formed. Committee declared as successful, and the, my lords, proposed for awarding of contract to me. At that stage, my lords, they don't pass any orders on that and call for fresh tender. My lords, therefore, my lords, it gives an impression that unless the respondents get a person, my lords, who is favorable to them, no contract is going to be awarded. My lords, annexed D, I am declared as successful, my lords, and there's a recommendation made. May I just draw your lordship's attention to page 118?
No, which order you are challenging?
My lords, I have challenged, my lords, calling for the fresh tender. Now, my lords,
Page 20 is the interim order, my lord, that has
yes,
been
that's what
implemented.
I understand. I know where I stand. I know the interim order that I have sought for. My lords, today, my lords, is the last date. Today is the date, my lords, fixed for opening the financial bid also. All that I am praying before your lordships is, my lords, let third party rights not be created. My lords, if it is created, then my writ petition, my lords, and my earlier application where I am declared as successful, virtually, my lords, becomes fait accompli. Nothing remains in my writ. There's nothing to be decided if third party rights are created. Let me just draw your lordship's attention to that portion where they have, my lords, today is the date fixed, my lords. All that I'm saying is, my lords, without passing any orders on the earlier tender, where I'm declared successful, recommendation is made to call for, my lords, fresh tenders. Under section 14, my lords.
No, what is the main prayer? Let us see.
Very well. Would your lordships come to page number 36, my lord?
So you wanted to set aside the tender notice,
The second one, yes, ma'am.
calling for fresh tender.
Fresh
in respect of
tender.
Wholesale transportation. by
Yes,
so
ma'am.
and so.
And D, my lords, prayer D is to give the work order if I'm otherwise eligible as per the first notification.
Now, when the matter is kept before learned single day,
No date, ma'am.
then go to learned single day and seek a memo, have a date.
My lord, it was adjourned. May I just point out? My lord, it was adjourned at the request of the respondent to file their statement of objections, and it is adjourned without a date. Today is the last date, my lord.
Then you could have gone to learned single judge.
We requested, my lord, we requested the learned single judge, my lord. Learned single judge refused to, my lord, said that there is no
Where is
urgency.
that order of refusal?
My lord, may I just point out the impugned order itself? Would your lordship? The impugned order is dated 30th of January, my lord, about 4 days back. 30th of January, page 19, my lords. Exactly about 4 working days ago, my lords, the learned single judge, my lords, refused to grant us an interim order. All that I am praying is, my lords, let third party rights not be created, my lords. I understand, my lords, it's a process of tender and I'll have to make out a case at the stage of final argument. But, my lords, if third party rights are created, nothing remains in my writ petition, my lords. My lords, in fact, as your lordship.
Such grievances in respect of the omission of learned single judge, not giving date, not acceding to your request for giving date, granting time to file objection, writ appeal will not lie.
My lords, I'm not on that, my lords. I'm only insofar as non-grant of interim prayer, my lords. Interim prayer, my lords, is also not granted. I'm not on, my lords, grant of time for them to file objections. Naturally, my lords, some time. But in the meantime, my lords, if tender is to
Filing such writ appeal, either you are
my lord, I'm not, my lords. My request is, though, my lords, I can point out from the pleading, my lord, but my request
either you are disregarding the level of the appellate court or otherwise, right? We don't.
I would not
But
want.
jurisdiction not for these purposes.
I'm only insofar as non-grant of interim prayer.
You go before learned single judge immediately. Request that this is the dire urgency. Have you gone?
On 30th, we pointed out, my lords, but learned single judge was not inclined to grant an interim order and adjourned it sine die. Therefore, my lords, today is the last date.
Today is the last.
Today.
11 a.m. today, my lord, page 221.
Yes, what do you say?
Page 221, my lord, today is the last day, 11 a.m. today, financial
Last date
bid.
for?
Last date for opening of the financial bid, my lord.
Financial.
11 AM today, the date,
Where is the
page
timetable?
number 221, my lord.
Where is the tender?
Lord, the tender starts from
Tender
page number
notice.
218, my lord.
There are two tenders.
Tenders, my lord,
One
wholesale
is
and
for
retail.
wholesale, one is for retail.
Retail.
Annexure K, my lords, is for Annexure J, page 138 is for wholesale. Annexure K, my lords, is for retail, which is at page number 220, my lords. Either of it, my lord, your lordships. Page 220.
And what is this, all individual tenderers who are the members of the petitioners?
My lord, at the first instance, my lord, the association
Yes,
filed the writ petition.
I anticipate.
The tenderers did
Your
not come before the court.
And your lordships, the only possible answer I have is this, my lord. All the
You are the petitioner.
yes, ma'am.
So what kind of sense this makes? This
Locus,
request?
my lord. Insofar as locus, my lord, my only answer.
Not locus.
Yes.
Why you are making everybody of your association?
Because, my lord, all the participants in the tenderers, my lord, are members of the association. All the successful as well as unsuccessful bidders, my lords, are a part of the association. Now, my lords, on the representative capacity, my lords, the association had made a representation to the contractor, my lord, saying that please proceed with the earlier tender, don't abandon it midway, that the members of the association who have participated have, my lords, incurred sufficient financial obligations. They have set up the entire machinery, my lords, to be successful in the tender. All of a sudden, if you were to abandon it right in the middle of the process, it would, my lords, cause prejudice to the members. Individually, my lords, all of them are made as parties, my lords. The association is the first petitioner. Individually, all of them are parties. If it is not impertinent, may I make this request? That's my only anxiety is this. If I'll move the learned single judge, my lords, at the earliest, my lords, in the interregnum, my lords, if third party rights is created, then, my lords, for me to, my lords, challenge the third party rights, my lords, then after awarding of contract or tender, my lords, then the grounds on which I can come before your lordships, my lords, would be very, very limited. In a similar case, my lords, in very recently in Bombay High Court, my lords, though held in favor of the petitioner, my lords.
This is contract
for transport of wholesale and retail food grains. From the wholesale go down to the retail foods go down, and from retail, my lords, to the fair price.
The writ petition is pending before learn a single judge, wherein the prayer made by the petitioner is to set aside the tender notification dated 21/1/25. In the proceedings of writ petition from alone a single judge, passed order dated 24/1/25, which was at the request of learned senior counsel appearing for the petitioner seeking to implead individual tenderers who were the members of the petitioner association. Full stop. Thereafter, on 30th/1/25, learn a single judge, paragraph, thereafter, paragraph. On 30th/1/25, learn a single judge granted a week's time. Learn a single judge passed the following order and quote this order. A week's time is granted to the respondents to file statement of objections. Paragraph. Essentially, it is against the aforesaid order dated 30th/1/25 that the appellate jurisdiction of this court is invoked, complaining the above order. Full stop. The only submission which could be, it would be immediately noticed. It is immediately noticeable that the aforesaid order does not reflect anything either on merits or nor decides anything. Full stop. It only grants time to the respondents to file the objections. There is no wrapping whatsoever of finality in the order. The writ petition is pending at large to be considered on merits for its prayers made as mentioned above. Paragraph. The only submission which could be canvassed by learned, which learned advocate petitioner, Mr. So and so urged before the court that in the tender process, the date for opening of the financial bid is today, and that the third party rights, if created, would render the petition virtually a fait accompli. Full stop. Even the said submission paragraph would not be countenanced inasmuch as when the court put a query to learned counsel for the petitioner as to whether the petitioner has approached learned single judge for early and immediate hearing of the matter in respect of grant of interim order in wake of what was submitted before us, before this court, namely that the last date of opening of the financial bid is today. Full stop. Learned advocate for the petitioner had no answer, and he was entirely at his receiving end, not able to state before the court that the petitioner had made any such attempt to approach the learned single judge. Full stop. The petitioner could have approached learned single judge and requested for appropriate order on merits and in accordance with law, even during the pendency and pending the filing of statement of objections by the other side. And just no case is made out, paragraph, to entertain in any manner the present writ appeal. However, this court leaves the petitioner at liberty to approach learned single judge and put forward its case, including on the grounds what is submitted before this court, namely that the financial bid is to be opened today and that it is likely that the third party rights will be created. Full stop. The writ petition number. What is the number? 1878 of 25 shall be listed preemptorily before learned single judge tomorrow. Full stop. The appellant petitioner shall be entitled to raise all the contentions to be considered in accordance with law. With the above limited observations, the appeal is not entered.
Very good. My only grievance was it was on 30th, 1 week it was adjourned.
We appreciate, but still we have limited.
I understand what followed.
Not that we are not appreciating.
I understand.
Our reaction may be harsh, but still we are appreciating.
So grateful. I'm obliged.
Yes.
So number 38, Arjun Rao.
So effective here for the appellant. What is under challenge, my lord, is the judgment of the learned single judge, page 28. Dispute arises, my lord, under the SARFACI Act. Appellant is the auction purchaser. Respondents, my lord, are the borrower and the bank. Grievance is, my lord, that by way of the impugned judgment, the learned single judge has, my lord, permitted the borrower to redeem the property even after sale is confirmed in my favor. And that, my lord, respectfully under section 13(8) could not have been done.
How can it be?
Page 28, my lord.
Sale is confirmed.
Sale is confirmed in my favor. In fact, my lord, I was not even made a party before the writ petition.
So this is leave to appeal.
I've sought leave. I filed a separate application. I've sought leave. I was not made a party. In fact, my lord, impugned judgment discloses that submissions were made that sale was confirmed. And may I please read, my lord, the judgment?
Where is the confirmation of sale is reflected?
Sorry, my lord.
From the record, you can show that the sale is confirmed.
Yes, my lord. Lordships may kindly take in the impugned judgment itself, my lord, page 29.
Impugned judgment itself.
Page 29. The submission of the bank, my lord, is recorded. Already put to auction and sold on 27/11/2024.
Yes, including the grant of sale certificate.
Yes.
Has he deposited
No, my lord.
the amount within 7 days?
No, he hasn't. He hasn't.
He's not deposited.
Then,
In fact, my lord, the respondent number 1 is not deposited the money with me. Till today, my lord, he is not deposited.
he has not deposited. Then you're not agreed by this order.
What would happen, my lord, is that by under this judgment, my lord, either he deposits within 7 days, or my lord, he is given liberty to make the same request before the tribunal.
See, either way, the matter will go on before debt recovery tribunal,
Yes, my lord.
right? That will be in accordance with law.
Yes, sir. But there is a finding in this, my lord. The finding is, my lord,
There is one recent Supreme Court judgment where it said once sale is confirmed, that's over. That's
yes,
the
my
end
lord.
of it.
May I please place that, my lord? Sealier versus Bharat.
It is very recent from.
Please, my lord. In fact, I quoted in other motion. Right of redemption, my lord, the borrower will lose, my lord, once sale notice is issued by the respondent bank.
Yes.
May you please point out from that judgment, my lord? Lordships
Yes,
may
yes.
kindly see para 4. Para 4, my lord. May I please read? This was the background, my lord. Paragraph 110 are the conclusions. Request your lordships to please take that. Second last page. Para 110, my lord, the conclusions. May you please read me. 110.1, the High Court was not justified in exercising its writ jurisdiction under Article 226, more particularly when the borrowers had already availed the alternative remedy available to them under Section 17 of the Act. 2, my lord, confirmation of sale by the bank under Rule 9(2) of the rules invests the successful auction purchaser with a vested right to obtain a certificate of sale of the immovable property in the form given in Appendix 5 to the rules, that is in accordance with Rule 9(6) of the rules. And 3, my lord, in accordance with the unamended Section 13(8) of SARFAESI Act, the right of the borrower to redeem the secured asset was available till the sale or transfer of such secured asset. In other words, the borrower's right of redemption did not stand terminated on the date of the auction sale, the secured asset itself, and remained alive till the transfer was completed in favor of the auction purchaser by registration of the sale certificate and delivery of possession of the secured asset. However, the amended provisions of Section 13(8) make it clear that the right of the borrower to redeem the secured asset stands extinguished thereunder on the very date of publication of the notice for public auction under Rule 9(1) of the 2002 rules. In effect, the right of redemption available to the borrower under the present statutory regime is drastically curtailed and would be available only till the date of publication of the notice under Rule 9(1), and not till the completion of sale or transfer of the secured asset in favor of the auction purchase.
Goes again. All is applicable to you. This unamended section applies to you.
Yes, my lord, it does.
So this paragraph is in your favor.
Yes, my lord. But here the sale notice is issued on 24th of October, where request for redemption is made in December.
Borrower's right of redemption did not stand terminated on the date of auctions of the secured asset itself. Remained alive till the transfer was completed.
Yes, that was the earlier regime.
Early.
And this amendment what came in the year 2016.
But here even the transfer is completed.
But sales certificate is not issued, confirmed in my favor.
Confirmed in.
Confirmed in.
Sales certificate notice.
Not issued, because there is an interim order passed by the tribunal.
Your for bank.
My lord, respond number 2, my lord, I take notice on behalf of respond number 2. They served a copy of it. Bank, I sold the property, I'm a secure creditor.
You are in behalf of number 2 means bank.
My lord, my lord, secure creditor, bank,
Authorized.
please, my lord.
So you might succeed by virtue of non-compliance of paragraph 5.
But the only difficulty would be, the order is in two limbs, my lord. Either they deposit in 7 days, or they make a similar prayer before the tribunal.
Learner single granted permission to.
Yes,
Even
the
right.
difficulty would be this, my lord. There is a finding. There is a finding that if he makes payment, he would be entitled to that relief. And that finding, my lord, will have a bearing on the tribunal.
Heard learned advocate, you are Mr. Arjun Rao for the appellant and learned
Vignesh Shetty, respond number 2.
for respondent 2. The challenge in this writ will by the appellant is addressed to judgment and order of learned single judge dated 15th January 25, whereby learned single judge has granted permission to the original petitioner, the borrower, to deposit the amount of rupees 4,03,13,000, which was the amount offered by the successful bidder in the auction held by the bank. The leverage to the borrower is granted after the sale is confirmed in the auction. Paragraph. While selling the order of learned single judge from a learned advocate for the appellant pressed into service the decision of the Supreme Court in Shalir SCLIR, Shalir LLP versus Bafna Motors Integrated Mumbai, bracket over private limited. 2024 to FCC page 1. More particularly, the observations and findings in paragraph 110.3 of the judgment. Notice to the respondents returnable on 6th of March. Learned advocate, Mr. Learned advocate respond to accepts notice. On
Please,
behalf
my lord, on behalf of respondent.
of authorized officer, Canara. The order of a single judge shall remain state.
Great.
Next matter. 39.
Serial number,
Come along, 39, next matter. On
this was which,
same,
now 40,
39, my lord.
39.
That has to come along with, there is another connected writ appeal. I'll just furnish the number to the court of the lordships, may call it along.
Well, when shall we list?
Monday
Monday?
or Tuesday. Lord.
What is the urgency?
The urgency is, my lord, elections have been stalled. But according to us, elections must have held long back. The term of the board has ended in November 2023.
Board of what?
Cooperative Bank District.
Regarding some disqualification?
No. The elections have, the term has come to an end. Elections had to be held. For one or the other reason, or the government is somehow protracting the issue.
Well, contempt have also been filed.
Contempt has been filed.
Contempt is also before your lordships at item number 65.
65.
Complying that letter single judge's order is not complying with the, your lordship directed to file an affidavit. That affidavit is also yet to be filed by the state.
Serial number 39.
39 and 65 also be taken up.
This appeal shall be listed along with writ appeal number.
Writ appeal number.
Number 194 of 20.
On 11th of February,
Along with contempt.
2024 5 and serial number 65. These contempt petitions will be listed with writ appeal number 180 of 2024.
Your
serial number 53. It is stage as of now is interlocutory applications. We have no objection in impleading all those statements. A date may be fixed for a final hearing.
What is PIL? Final hearing will take up 21st February.
Serial number 73, my lord. This is the third consecutive contempt petition filed with respect of not conducting body work. Even after a lapse of 1 year, the order passed by your lordship have not been complied with. Kindly for a moment, in contempt proceeding, a direction was given.
Every order is of every lordship. So emphasizing your lordship will not make your case good.
No. This bench, what I meant is this bench.
Then you mean it.
Yes, I meant only that, not exactly you are.
Don't want any emphasis for us.
No, this bench only I
All
meant.
benches are equal.
No, correct, I agree, my lord.
I understand your.
I meant this bench. Maybe, I am sorry, your lordship.
I am very touchy about the language in the court.
No.
Yes, what do you want?
It may kindly be taken up at an early date because the third consecutive petition.
It will go to 25th of February.
Lord, serial number 46 may be,
42, my lord.
Pardon?
42
46 may be taken up on Monday, my lord. 46 serial number.
Which one?
46, serial number 46 may be taken up on Monday. As I am for the
Oh.
respondent 3, he is a student of veterinary science. He is, because of this appeals, he is suffering and almost 2 years he lost, my lord. 46, next Monday, my lord.
Is it that urgent?
Lords appearing for appellants, my lord. Lords, this is the case where the.
Vaishali Hegde.
Please, my lords, appearing on behalf of petitioners, appellants, my lord.
We understand, we recollect the case.
Please.
We have granted the interest.
Please, my lords, this is the case where the petitioner herself had given up her prayer in the
We
previous.
keep it on 17th, Mr. 17th or 18th. 18th.
Oblige.
My lords, in this matter, Veterinary Council of India has to file objections, man. Please.
Let us.
Please.
Any,
At 42, my lord, kindly call this matter on third week of this month, my lord. Because thrice it was listed before the Sound Court. It is not me reaching, my lord.
pardon.
42, my lord, serial.
So when do you? 18th, 19th,
Yes, yes. Much
19th.
highly obliged.
19th,
Number 41,
Last.
green bench matter, Your Lordship.
41, yes.
The demand, due to the demand notice, Your Lordship, the mining rights of the petitioner has been restricted in the other mining quarries also. So may kindly fix the date. Yes. 2023, my Lordship, notice also.
28th of February.
Obliged.
But definitely on the Lordship's, they will going to complete the order within a 1 week. May kindly have it in the next week.
Which one?
The serial number 91.
Or like whatever date you want.
Serial number 60.
ರೆಡ್ ಅಪೀಲ್ ನಂಬರ್ ಬರ್ಕೊಂಡ್ರಿ ಅಲ್ಲ ಸರ್ ಲೈಬ್ರೆ WA
Serial number 72, sir.
Court officer serial number 94.
Court officer. Court officer.
1 minute, wait, ma'am.
Yes, sir.
Court officer serial number 94.
So serial number 87.
Serial number 60. 60.
Serial number 55. Earlier year and 55 earlier. The short accommodate.
55, ಯಾಕೆಂದ್ರೆ earlier hearing ನಾನು 55.
ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗಿ ಹಾಕ್ಬಿಡಿ ಸರ್, ಆಗ್ತಾ ಇದೆ ಅದು process.
ಹಾ.
ಮತ್ತೆ ಡೇಟ್ ತಗೊಂಡ್ ಮತ್ತೆ ಯಾಕೆ
55.
51, 51. Sir, 51.
ಸರ್ 72 ಒಂದು ನೋಡಿ ಸರ್. ಹೇಳ್ಬಿಡಿ ಸರ್ ಇಲ್ಲ ಸರ್.
Sir, 51, 51.
55 ನಾನು 55 ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗಿ ಹಾಕ್ಸ್ಕೊಳ್ಳಿ, process ಆಗ್ತಾ ಇದೆ.
So serial number 87.
ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ನಾವು ಟೈಮ್ ತಗೋತೀವಿ ಅದಕ್ಕೆ.
ಮೇಡಮ್ ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ, ಒಂದು half an hour ಅಲ್ಲಿ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ, ನೋಡ್ಕೊಳ್ಳಿ.
Sir, please serial number 87, if 12th of March can